Yes.
Okay, I'm not pressing this second. I'm not pressing this second. Sort it out like
The instant appeal arises out of the judgment and decree dated 14/5/2013, entitled Appeal Number 27/2012, passed by the Court of the Civil Judge Karimganj, Mr. S.P. Chaudhary, the learned counsel, appearing on behalf of the appellate, upon instruction, submits that the appellate does not want to, appellants do not want to press the instant appeal. Accordingly, the instant appeal stands dismissed and withdrawn. In term of the any application, the registry shall return the LCR
this
to the
affidavit may be kept on spot. This affidavit may be kept on spot because
What
there is a
affidavit?
communication with regard to they are not used. Paragraph 4 there.
During the learned does not want to press on instructions. During the course of the hearing, the learned counsel has also produced a certificate and affidavit of who?
The appellate number 2 law.
The appellant number 2, wherein it has been categorically mentioned that the appellant do not wish to proceed with the instant appeal. The said affidavit is kept on record and marked the letter text. Accordingly, the appeal stands dismissed on withdrawal. The registry shall return the LC. Both.
Yes. Joint affidavit on record. Just filed sometimes in the month of December.
It has been submitted to the bar by Ms. Duenko, appearing on behalf of the appellant in FAO number, appellants in FAO number 31 of 2018 and CRP IO number and petitioners in CRP IO number 320 of 2019 that the appellant, that the appellant oblique the petitioner are not inclined to proceed with the instant proceedings, and accordingly submits that the and accordingly proceed with it. Accordingly, both the FAO number 31 of 2018 and CRPIO number 320 of 2019 are dismissed on withdrawal. Interlocutory orders passed, if any, stands vacated, and the parties being duly represented before this court are directed to appear before the Court of the Civil Judge number 1, Kamrup Metro at Guwahati, in title suit number 429 of 2017 on 25, 2024. Yes,
Yeah, please a lot. A lot of this case, yeah, okay. The Pulta is out of station.
Huh?
Is out of station, your lordship.
Who?
PK Pulta, senior advocate, your lordship. PK Pulta. Recently, he met with an accident. That's why he is out of station, your lordship. In Kolkata.
what is left in this proceeding?
Your lordship, I don't have the brief with me.
Don't appear. There are many other counsels who are there.
Your lordship, my senior left in a hurry, so I was
Who is your senior?
senior advocate PK Pulta.
He's a senior counsel, isn't he? So, the responsibility lies upon whom? In a matter? Did you sign the Wakalaknama? Then, the responsibility is yours. Are you suggesting that your senior had carried the brave back out there to where?
Kolkata.
Kolkata?
Oh, yes.
Then, you make this type of submission. What are you challenging here?
Your
What is he challenging?
Your lordship, in this case, the petition number, the petition, and the judgment after in the faculty division, I challenged an application I've filed under section 47 of the CPC, which has been rejected.
Hmm.
I'm challenging that on.
But a decree has already been executed.
Yes, sir.
Then what remains?
Lordship, there are some questions to be determined. My senior will be with
Hmm?
There are some questions to be determined.
So there being no stay, nothing is there. Decree has been executed. Then
But only half portion, your lordship.
No, Lordship, no. Already that proceeding has been closed. I have annexed that order also with my affidavit.
you have filed an affidavit, na?
Yes, Lordship.
Where is that order? Date?
Yes. Okay.
And how are you filing 227? At best, it would have been up to proceedings on 115. Isn't it? Then where is that order?
Order is at page 183 of my affidavit.
So you should be happy. You say half of it has been done. He says the entire has been done. So they can't go for any further execution. Then
Lordship, on the last date, you have suggested so. But a last chance may be given. That's because my senior is
the matter has been wrongly listed as a motion. in a motion column, taking into account that the notice was issued as far back as on 28/2/2024. The learned counsel, appearing on behalf of the respondent, duly submits that the decree has already been executed and nothing further remains.
Yes.
On the other hand, the learned counsel, appearing on behalf of the petitioner, further seeks for an accommodation. Accordingly, let this matter be listed after, for admission, after the summer holidays. Summer vacation. Summer. Yes, Mr. Bhatti, what are you challenging?
My lord, the order dated 13/3/2020,
Huh? Page
page 20, my
20.
22, passed by the learned tribunal.
Debt recovery tribunal.
My lord, the application was filed under section 1925. That
Oh.
is the inherent power of the learned tribunal.
Ah.
And that application was dictated. Your lordship will find the finding at 24. Because I pointed out the mistake which has been committed by the learned tribunal.
Hmm.
Regarding my personal guarantee, since my predecessor in this did not execute any personal guarantee, and in spite of that fact,
That too after 6 years.
yes, that is there.
Then
That is there, my. But it's still no third party interest has been created. No property has been taken away from me. My personal property, and that's why my lord, in view of the judgment, this judgment reported the finality 2023 5 ICC, my lord, page 267.
Hmm.
If your lordship will go paragraph 30, 31 and 32, my lord, I am giving this copy of the judge. And so far the delay of 6 years is concerned that I have explained in my application, why the application. My lord, I cannot be left with limited death if I can point out the mistakes that been committed by the planet.
did you file an appeal?
No, I
Then what is this type of application?
my lord, in this particular case, the appeal, if I file section 20 says about the appeal.
Huh?
20, section 20 of the act says about the appeal. My lord, have a look that section 21 says that I have to pay 50% of the tax.
So
That means what I am submitting back. Here is not the question of dissemination of that liability. Here is the question whether I am personally liable. That is only the
you were a
question.
party there? You were a party to that proceeding?
Yes,
You did not submit your written statement?
I did not submit my written statement.
Then the court proceeded,
Yes,
court decided,
my
you have not
court
challenged this, and now you are trying to take out another by filing an application.
Yes, my lord.
I think the only remedy now left with you is to go to the Supreme Court when I dismiss it.
Yes, that is a different
No,
expression.
that is the only remedy.
Because-
You say that there is no other remedy left. The remedy lies under 136.
What I am going to point out, my lord, your lordship may.
You cannot reopen a thing which has been closed. There is a finality attached to it.
My lord, even
And
though
by
this,
filing an IA or miscase, you
my
cannot.
lord, this judgment, so far I refer judgment, if you will go to paragraph 30, 31, 32, 33, 34 of the judgment file.
What
See,
does it say?
It says that in case even in finality, if the court has committed the mistake, it can be corrected.
The mistake of the court. Why there was a mistake of the court?
Because I did not furnish any kind of personal guarantee. There's no pleading
So Anasa sir, you should have
at all.
pointed it out.
at all.
You
There's
should have
no
pointed it
pleading
out.
at
You
all.
should have challenged it
Other,
in a
there's
deal.
no finding that I submitted the personal guarantee.
If there's no finding or not, that is immaterial. This court is not going to look into this.
30, 31, 32, 33, 34, this judgment, this judgment is widely applicable in my,
How? Let us read it.
my lord.
Which paragraph you are referring to?
I have no other copy, my.
Take this.
I have
Look,
given it for your lordship, my. Even though my lord, some paragraphs I have,
No.
even though your lordship may
3, 5, 6, 6, 7. I look it from my
paragraph 30.
6 to 7.
May I read it, my?
Just 1 minute. Yes. Read it. Para
30. This,
30.
may I read it, my?
Hmm.
This court in the aforesaid case held that the concern of the court for raising justice is a court is not less important than the principle of finality of itself. The court has to balance and ensuring certainty of finality of the last law on one hand and dispensing justice on the inquiry of a judgment of the native ground on the other hand. This court has observed that though the judges of the high court do their best, yet decisions may arise in the clearest of their cases. This could require the consideration of a final judgment to state right miscarriage of justice complex. It has been held that in such a case it would not be proper, but also obligatory both legally and more to rectify the error. This court further held that to prevent the abuse of this process to cure a gross miscarriage of justice, the court may reconsider judgment in exercise of its discretion.
Then?
Then my lord 31. Then 31, my.
Yeah.
This court, now their lordship, I'm reading. Now their
Come to
lordship,
paragraph 32.
yes, no. 32. It could thus be seen that the principle of individual justice has been emphasized. This court in Antule has that no man should suffer because of the mistake of the court. No man should suffer a wrong by taking prostitute or illegality. It has been held that the fruits of prostitute are the handmaids of justice and not the mistress of justice. It has further been held that if a man has been wrong, so long as the wrong lies within human machinery of administration, the wrong must be able. Again, my lord, the last paragraph. Once that this discussion was not open to be made, and it is accepted as a mistake of the court. It is not only appropriate but also the duty of the court to rectify the mistake by exercising inherent power. Judicial opinion heavily lean in favor of the view that the mistake of the court can be corrected by the court itself without any result. This is on the principles as indicated in personal touch. I am of the view that in the particular situation, the court's inherent power can be exercised to the best. My lord,
Mr. Bhatti, the facts of the case. A writ petition was filed. Various petitions were filed, wherein there was a direction made by the RBI to disclose certain information pertaining to certain confidential information of certain. That was put to challenge
Yeah.
by the banks and the private. Thereupon, a submission was made that similar matters came up before the court, and those matters were duly, and therein a judgment has been passed that such writ petitions are not made. That was the preliminary objection being made. In fact, therefore, the submission was that look here, if you now entertain this type of writ petition, it would have the effect of rendering the earlier judgment useless. It is under such facts this judgment was delivered. A thing which has been a judgment which was pronounced earlier, maybe it may be wrong or right, we still have the power to reconsider. That is, but here is a case in respect to the same judgment. You are asking of a modification or an alteration under 151, saying it to be a mistake of the court with that too on a particular fact, which is a case which you ought to have filed an appeal.
I feel that is right, Mike.
Then-
That is right, my lord.
No, I think you have a remedy under 136. Let me dismiss it right now.
My lord, the property alternative remedy is concerned. May I point out one?
Not the alternative remedy business out here. This is not a case of alternative remedy. It is a
Yeah.
case where you could, the order which has been passed has been rightly. You could not have challenged this. You could have very well filed an appeal. There were,
Because
I think when you file an appeal, you can very well file an application for condonation of delay.
My
one.
lord, that is the.
Secondly, you can very well file an application for waiver of the pre-deposit. You can very well file. They may allow, they may not allow, that is their look. We are not concerned to that. But you cannot, on the basis of that, come before this court. And allowing or entertaining such type of petitions would open floodgates.
My lord, that is the delay of 6 years, no doubt at all. Because my predecessor is not tell me about it.
No, let
Right.
me dictate.
Dictate, my lord, in that
Dismiss.
case, my lord, I may be delegated to the alternative remedy.
I can't relegate it. If you withdraw, I may say that he may very well prefer remedies available under law.
My lord, in that case, my lord, let it come on Monday
No,
so that I can have.
no Monday. Monday, we have already spent 15 minutes of time in
See,
this.
no doubt, man. And but on
I
Monday,
can
my
do
lord,
one
only
thing.
to intimate your lordship.
No. I can do one thing. Let me dismiss the matter and saying that it would, however, be open to the heir to avail such remedies otherwise available under law.
Yeah.
So your only concern is you cannot withdraw without taking the consent. So don't forget about the consent, not necessary. Anyway. Heard Mr. O.P. Bhatti, the learned counsel, appearing on behalf of the petitioner, and Mr.
G. Das, Lordship, on behalf of Respondent Corporation.
Mr.
G. Das, Siddhartha Das.
Sida, appearing on behalf of the respondent. The instant application under Article 227 of the Constitution is filed challenging the order dated 13/3/2024, passed by the Learned Debt Recovery Tribunal, Guwahati, in MA number 163/2023, arising out of original application number 244/2014. The brief facts leading to the filing of the instant application is that
Page 90, my
the respondent herein had filed an original application number 244/2014. seeking recovery of an amount of rupees
Equator 80 lakhs, page 61, Lordship.
Where is the order?
Order,
First
my
initial
lord,
order.
page 20.
61.
Very good, good. Seeking recovery of an amount of rupees 3 crores 80 lakhs 39,645 along with pendant light and future interest at contractual rates till realization. The petitioners herein are the successor in interest of the opposite party number 7. You call it opposite, defendant number 7
Defendant.
in the said proceedings. Now, the defendant numbers 1, 2, 4, 5, and 7.
Six.
4, 5, and 7. Though participated in the said proceedings before the learned DRT, but did not file their written statement. However, the defendant number 3 and 6 had contested the claim of the applicant of the respondent bank by filing written statement. The learned debt recovery tribunal, Guwahati, by the judgment dated 7/9/2016, decided the said original application in favor of the respondent bank, respondent herein, who was the applicant in the said proceeding, and issued recovery certificate in to the tune of rupees 3 crores 80 lakh 39,645, together with pendant light and future interest at the rate of 13% per annum till realization of the amount in full along with cost of the application. The charge on the various properties which were mentioned, which were a part of the application, was kept alive till the full and final realization of the amount. The petitioners herein, who are the successor in interest of the defendant number 7 in the said proceeding, thereupon, in the year 2024-23, filed an application which was registered as miscellaneous application number 163/2023, stating inter alia that their predecessor in interest ought not to have been made personally liable, in absence of a personal guarantee having been executed by the predecessor in interest of the petitioner, and their liability was limited only to the sale proceeds of the mortgage property. Pursuant to the said application so filed, the respondent herein filed an objection opposing the said application vehemently. And also, vehement, in the said objection, it was duly mentioned that the said interlocutory application has been filed only to delay and or stall the recovery proceedings after necessary directions were issued by the learned recovery officer on 11/7/2023 to the legal heirs of late Ambika Borua to disclose their property details. It was also mentioned that the petitioners herein have duly approached the learned recovery officer for alteration of the modification of the order dated 11/7/2023, which was, however, rejected by an order dated 19/9/2023. It was further mentioned that after a period of 6 years from the date of the judgment passed in the original application, the instant application has been filed seeking modification, alteration of the correction of the judgment and the certificate dated 7/9/2016 passed in OA number 244/2014 with the sole object of obstructing the recovery proceedings. The learned presiding officer, DRT, Debt Recovery Tribunal, Guwahati, by the impugned order dated 13/3/2024, rejected the said application filed by the petitioner, and it is under such circumstances that the instant application has been filed by invoking the superintending power of this court under Article 227 of the Constitution. I've heard Mr. O.P. Bhatti, the learned counsel, appearing on behalf of the petitioner, and Mr. So-and-so appearing on behalf of the respondents, and have duly taken note of their submissions. Mr. O.P. Bhatti, the learned counsel, submitted that the predecessor in interest of the petitioner never provided any never furnished any personal guarantee. And as such, the judgment passed in the original application being dated 7/9/2016 was a mistake being committed by the learned DRT. And as such a mistake ought to have been corrected, as it was on account of the fault of the learned DRT that the instant proceeding, that the predecessor in interest of the plaintiff, of the petitioners, as well as the petitioners, are now facing due difficulties. The learned counsel further referred to the judgment of the Supreme Court in the case of HDFC Bank Limited and others versus Union of India and others, reported in 2023 5 SCC 627, and submitted that the court, in view of the principle of ex debitio justitia, can reconsider a decision even if the said decision have attained finality, if the said decision is a result of a mistake of the court. In that regard, he specifically referred to paragraph 30 and 32 of the said judgment. Anything else? Nothing more. On the other hand, the learned counsel, appearing on behalf of the respondent, submitted that the application which was filed almost of 6 years from the passing of the judgment, that too in a case where the predecessor of the petitioner had duly participated in the said proceedings and did not submit a written statement, is nothing but a ploy employed by the petitioners at the behest of themselves, or for and on behalf of themselves, as well as the other, what do you call them? Certificate debtors. Certificate debtors, to delay and stall the recovery proceedings. He submitted that the said judgment and decree, the said judgment passed by the learned Debt Recovery Tribunal could have been very well challenged before the appropriate forum. As is visualized in the Recovery of Debts and Bankruptcy Act 1993, for short the Act of 1993. And having not done so, now, after a period of 6 years to file that application, that too, assailing the said judgment on certain facts, was not at all maintainable, for which the learned DRT was justified in rejecting the said application. He further submitted that the judgment so referred to by the learned counsel, appearing on behalf of the petitioner, cannot be applied to the facts of the instant case, taking into account that the judgment was rendered in some different facts, which has no application to the present facts. Upon hearing the learned counsels appearing on behalf of the petitioner, and this court have given a due consideration to the respective contentions, from the materials on record as is available, it would be seen that the respondent number 7, defendant number 7 in the original proceeding, was the predecessor in interest of the defendant, of the petitioners herein. The judgment so passed by the learned DRT on 7/9/2016 categorically holds that the various defendants, including that all the defendants except the defendant number 3 and 6 filed their written statement. The record for the said judgment also reveals that the respondent number 7, defendant number 7, who was the predecessor in interest of the petitioner, had also participated in the said proceedings, but did not submit the written statement. This court is also of the opinion. Did not. Under such circumstances, the learned DRT have duly taken note of the various materials on the court and have come and have decided and had passed the judgment on 7/9/2016, thereby allowing the said application filed by the respondent bank herein. It would be further apparent that the predecessor in interest of the petitioner very well knew about the said judgment passed by the learned DRT on 7/9/2016 and did not assail the same during his lifetime. At the present stage, almost after 6 years therefrom, the application was filed by the successors in interest of the respondent of the defendant number 7, that is the petitioner's hearing, alleging that there was a mistake being committed by the learned DRT in passing the impugned judgment dated 7/9/2016. This court finds it very pertinent at this stage to mention that a mistake committed by the court cannot be equated to an erroneous judgment being passed by the court. This court at this stage finds it very relevant to take note of inasmuch as a mistake so committed has to be a mistake by the court. And on account of such a mistake, there has been a prejudice to a party. The same, however, cannot be the same as already stated, cannot, however, be equated to an erroneous judgment and is based upon the principle that on account of that no act on the part of the court should prejudice a party. In the instant case, if this court takes note of the facts as already delineated here in above, it would be seen that the petitioners herein, the predecessor of the petitioners herein did not participate in the proceedings before the learned DRT by filing written statement or clarifying their stand. The learned DRT had, on the basis of the materials on record, have passed the said impugned, had passed the judgment dated 7/9/2016. Under such circumstances, the said cannot, by any stretch of imagination, be said to be a mistake committed by the court, thereby prejudicing the respondent, the petitioners, or their predecessor in interest. On the fault of the court. At this stage, if this court now takes note of the judgment of the Supreme Court in the case of HDFC Bank Limited, it would be seen that the said case pertained to the said judgment was rendered in the case in respect to a reconsideration of a judgment passed in another case. On the principle that merely because a judgment has been pronounced by the Supreme Court, the same cannot be said that it cannot be reconsidered. The same, in the opinion of this court, the said judgment do not apply to the facts of the instant case. Accordingly, this court finds no merit in the instant application, for which the same stands dismissed. Recently, the Supreme Court also came, and this is under 151 also, the power to recall is to be done within 3 years, because the Limitation Act applies. Let us not put so much of a death knell to him. Anyway, it is, however, observed that the dismissal of the instant application shall not prejudice the petitioners to avail such other remedies if otherwise permissible under law. Yes, what is this contempt business? If the contempt decision is so big, then what to do?
For non-compliance of an order passed by the subordinate court of
Huh?
by the learned court of judicial magistrate first class from six.
Then why you're not going there?
Repeated by that non-compliance, my lord, we have made petitions before the court below, my lord.
Huh?
But only direction was given to allow the petitioners to have a telephonic or video call with the child, my lord. But it's still, my lord, in spite of several orders, my lord, still that it is not allowed to have a conversation with my conversation with my.
You want to meet your child,
Yes, my lord.
which have not been permitted.
Even a telephonic or video conference, telephonic and video conference, my lord, is not allowed, my lord. I have repeatedly called my wife, my lord, and requested her through, my lord, SMS, my lord. In all of it,
So it is already there. There is already a direction.
my lord. Direction is there, but there are repeated direction, my lord. But in spite of that, my lord, not about even the respondent, my lord, did not object in all the petitions I have filed before the Garnet court.
So what?
But in spite of-
You already go there.
Yes, I
It is was fixed on 6/4. What happened on 6/4?
6/4, my lord. On 6/4, my lord, and page number.
It is not there.
My lord, at 6/3, my lord, in 6/3, my lord, there is a
6/3 I've looked into. 6/4, what happened?
on-
This is the matter again on Wednesday, next week, on which did the learned counsel appearing on behalf of the petitioner shall apprise as to what is the status of the present proceedings after 6/4/2024.
Wednesday, my lord.
Next.
Okay.
Or a bit. For the last because in your lordship passed an order directing the respondent to file an affidavit.
What is this? Why is this matter here?
But it is a partner.
Part heard. There cannot be any part heard. Oh, that matter.
Yes.
Yes, what is it?
Lordship, I have already filed the affidavit, your Lordship.
Huh?
Everything has already filed, your Lordship.
Well, what was this? Taking into account this court direct the respondent motively as well as the home heir to file affidavit stating the entitlement of the petitioner in respect terms to the directions mentioned in 12 and 13 of the order dated 15/2. Yes, what is the entitlement?
26,88,399.
399.34.
Yes, now when you are paying that, where is that amount?
That is in affidavit page
Yes,
25.
26,88,934.65 for the period from remand on account of occupation of the petitioner's land since 95, calculating 9% interest for the first year from the take of pay and 15% after the completion of the first year under section 80 of remand as per that. So you are okay with this amount?
Fine.
Okay, when are you paying?
Within-
Ask Mr. BJ Talukdar to be appearing.
Lordship, he is hospitalized, your Lordship.
Okay, get a hold of you. Can you say anything when you are paying?
Within 6 months.
Huh?
Within 6 months.
Your land is in occupation?
What?
Nothing doing. Ask that person to be present. Who is that person?
Deputy Commissioner.
This is the police station.
Yes, Lordship, I am police.
My goodness. Ask the DGP.
Lordship,
We'll ask the DGP to be
Mr.
present. What is this going on? The police is to protect the property of the persons, and now the police has
Lordship,
taken over like
already-
this
already-
and not paying, and now you're
No,
saying the 6 months.
No, Lordship,
Nothing doing.
already 2 installments is paid, your Lordship.
What? 26 lakhs now
No,
have
no,
to be
already,
paid.
Original,
How much you are entitled now?
not 26 lakh.
Then?
Interest.
26 lakhs when you are paying.
Lordship, now calculating that amount. Now this amount has to be paid, your Lordship.
When?
You will pay, your Lordship. Already 2 amount has already been paid, your
When?
Lordship.
I'm not saying then. When? We'll have it on Monday.
No,
Monday.
Yes,
Give
sir.
us the
Lordship.
information when. And don't come up with all these things. Or that police station, they have a house?
Yes.
They built a house.
Yes.
So you go and stay there.
Lordship, Monday.
You break the lockups and all in the meantime.
Lordship, Tuesday, pick them up Tuesday.
You break the lockups and all, make it habitable for them to stay. You stay there. And you vacate that place.
Monday, Lord.
Monday. Monday, come up with a definite figure. And it can't be more than 1 month. Tell your DGP, whoever it is. It has to be before Monday. Monday is 29. Before 29/5/2024, the amount has to be paid. Nothing to it. 29/5/2024. If it is not paid, vacate that, give it to him. He will stay there. And break that lockup. He doesn't want the lockup. You want the lockup? No. Break that lockup. I'm having it on Monday. List the matter again on Monday. My goodness. So many years. How many years?
From 1995.
My goodness.
No, Lordship, land has been acquired 2017, your Lord.
Why?
2017. Land has been
Unless this court would not have taken up this matter, you would not have done that also. You are to protect the rights of the citizen. And you are taking over the rights of the citizen by force. You did not acquire the land. You did not do anything. Nothing was done by you. This police cannot do like this. On Monday, come up. It has to be paid before 29/5. Because Monday is 29/4. Before 29/5. Then I fix the matter on 1st of June. And on that day, it has to be said by him, I have received my amount. Nothing doing. Tell your whoever it is. If you don't have money, sell your cars. You have some police, some vehicles, na? They have the vehicles out there. The commissioner of police has a vehicle.
government.
Huh? The
Government.
commissioner of the police has vehicle.
Government vehicle.
So tell that. The government also vehicles can be sold. Tell those vehicles.
Apply.
This is the matter again. Yes, why is this appeal before this court?
Appellant probate petition rejected by the on the ground of Bhatpata Limited.
On the ground?
Bhatpata Limited.
Very well.
Article 137 of Limitation Act, there is no period of.
When did you get that year? There is a judgment of Justice Ansari, which was confirmed by the Supreme Court, wherein it says it has to be 3 years.
Article 137.
Huh?
Article 137.
That is the 137 only. You can't file it one fine morning and do whatever you like. And the judgment was passed on 22/12/1/2023. Why the appeal is today? There was a delay.
Within a limitation period. Within limited.
Then why the matter has come up today? You filed it
Not
on 19/4/2024. How is it possible when the judgment was passed in 2013?
No, my letter 2024, not 2020.
There's some mistake. Oh, 2024. Yes, tell me why it was held to be delayed. Oh, your petition was dismissed.
Yes.
Very well. Let it go for another 15 years. Appeal admitted, call for a record issue notes. Returnable 6 weeks.
Okay.
Hard to answer. Yes, the appellant is not before the court. You are the respondent.
Yes, sir.
Yes, what happened?
He prayed
What
for
is this
divorce.
matter about?
This is met appeal lordship, and he has prayed for divorce before, and that was rejected.
Against that, he has filed an appeal.
Yes, against that.
Okay, we'll admit it.
Yes, Lord.
So, divorce having been rejected, appeal,
Yes,
Okay.
Lord.
you are now husband, wife.
Yeah. Yes, we are husband.
It was, yeah,
And I'm residing in his household, in my matrimonial home.
where? Appeal, admitted, call for, yeah, need to know. Issue notice is already there.
Yes,
She's
Lord.
appeared. So, no notice. Appeal is admitted, call for the LCR. Ms. Coento D. Ghosh appears on behalf of the sole respondent and accepts notice. No further notice is required. List the matter for hearing immediately upon receipt of the LCR.
Deep privilege.
Yes, what is this FAO?
Was prepared by the order dated 11/9/2020.
Where is that order?
Order is at page 45 and Annexure 5.
Your miscase has been dismissed. What did you ask for?
I asked for injunction not to make any agreement for sale, deed of sale mortgage.
What was the wage you're playing?
What my paint is at, Annexure 1, page 15.
Age 15.
15.
Suit for declaration that the agreement for sale entered into between the defendant number one with the plaintiff is legal and valid for specific performance. And the suit was filed in the year 2023.
23.
And agreement for sale was of 25/3/2013. Then what was the terms of the agreement for sale?
My terms was that, page 23, para 24. And from there, the state agreement for sale data does not contain a specific clause by clause 4, wherein the period of execution of the sale deed it was mentioned as 112 months up to 25/7/2020.
So,
Okay, during this period, a miscase has been filed before the circle officer.
Hmm?
This case has been filed
for what?
for execution, maybe execution process. But the circle officer has said that this is not appropriate before me, so directed to file this.
How was this appeal? এখন appeal কেনেকে pass হয় no? Three paper খন pass কৰিব পাৰে নেকি? পাৰেনে? Eh? Huh? Where is your agreement?
Remand is not
Then it was to be completed within 12 months. You are saying 112 months. And that is why the agreement is, and that is one of the main reasons that your petition is not maintainable. Your suit is not maintainable. Isn't that the reason? Isn't that not the reason?
the contention is there. But my contention is that page
Yes.
page 23, okay?
Hmm.
Page 23, para 4, okay? The plain code.
Forget about the plain. Why haven't you not enclosed the agreement?
File an additional.
File it. The court is not inclined at all. This is a fit case for dismissal. And with cost,
So I will file the appeal.
with cost. Because what type of documents you have enclosed?
So I will,
Why the written statement is all black? I don't know. You can read it or not. How did you manage the registry? I don't know. See, Is it-
here, if
Could you go in
section has been,
how did it happen? How can you manage the registry? On that ground only your appeal should be allowed. Because the council was such an expert in managing the ministry.
it has not been.
Huh?
Yes.
All that registry fellow who has done it. What is his name? All that. We'll take it up with him. Before further going, let us take people from here. Age of the petitioner required. Advocate signature, there is a certificate so and so. Annexure 5 mentioned in the index not made annexure at body of the petition. Then not rectified. Wait. Did you mention the matter?
Oh.
How did it come up then?
So the
And what is the stage of the suit?
It is going on
What is the stage? The order was passed long time back.
long time.
Then
But the day of motion, there was some typographical errors in my, I have taken time to correct,
then
and it was not listed for a long time.
no, that was not listed because you corrected it only on 15 to 2024. And what correction you have done is you only know and they only know. Objection compliance date 9/2. Yes. Okay, we on these message, I will dismiss the appeal.
Where I file an additional affidavit, I will bring the plaint along with the WS and WS what affidavit they have filed and the
And what else? The agreement,
agreement.
original.
Yeah.
And then it's in the Assamese
Full translate it.
translate. How much time? 6 weeks, 6 months, 6 years. Which one?
After 2 weeks. After 2 weeks.
2 months.
2 weeks.
Mr. S.J. Sama, S.J. Sama,
Yes.
the learned counsel appearing on behalf of the appellant submits that there admits to the fact that the written statement as well as the written objection so filed, so enclosed to the instant memo of appeal is not at all legible. He further this court during the course of the hearing also inquired as regards the agreement for sale. He submits that he will bring better copies of the written statement and the written objection as well as the agreement for sale by filing an additional affidavit. This is the matter on 3rd of June 2024. In the meantime, the such additional affidavit.
All right.
What is this? RSA.
My lord, there is a IA also, my lord, for correction of post title, my lord. Yes,
Yes, tell me.
my lord,
You didn't have a case, I suppose.
my lord.
Once it has come before me and now has gone back, meaning thereby you didn't have a case. I was supposed to dismiss. Was it? Otherwise, why will the matter be listed after? Yes, tell me. What is the substantial question of law?
My lord, forwarding your lord, of the order, my lord.
Oh, that matter.
Matter, my
Now I remember. There is a correction required.
My lord, correction, my lord, I have filed the IA, my lord, IA is here. IA number, my lord.
No, Mr. Counsel, I think what you need to do, there is a mistake out here. First, you have to correct it.
My lord.
Then you have to file an amended memo of party.
My
Then only we can take it up.
My,
Isn't it?
my lord,
Ganta ke par.
my lord.
Okay. This is an application filed seeking correction of the course title in respect to the correct name and address of the respondent number 1. This court have duly perused the application and is of the opinion that the said application merits, and accordingly the said application stands allowed, thereby permitting the applicant to amend the course title by incorporating the name and address of the respondent number 1 by the address which have been mentioned in the instant application. Accordingly, this court further directs the counsel appearing on behalf of the applicant to file an amended memo of parties before the registry of this court by Monday,
My,
29th.
Right.
Thereupon, the registry is directed to make necessary corrections in the course title and also update the same in the CIS. The registry shall thereupon list I stands disposed. Hold main list the matter again on. You'll give it on 29, na?
my lord, my lord. On Monday, I will submit.
Okay. List the matter on 3rd of May.
My lord.
I'm appealing for
To
respondent.
RSC. Yes, give your name properly. Not it. Yes. What are the let's see what is the case. What is the case about?
But it's, look, this is the dispute between two tea gardens. The appellant tea garden is owned by Assam Tea Corporation. It's the government garden, Longai Tea. It is situated adjacent to one private tea garden that Pakini Tea Estate, owned by another company now. That's the basic. Now
Then it was a suit for what?
they should file lordship at page 70, 70. A declaration of the plaintiff's right at interest. Raise the debt at page 75.
So you say that you have purchased this in some from the official liquidator, this lot of land.
That is but that is unfortunately lordship in suit after filing the WS. After filing the WS, the defenses have taken no steps because of the fault of that time, I mean the manager of the tea garden, of the Assam Tea Corporation.
You did not submit evidence,
Nothing, but they think that we PWG are not so examined.
not examined.
Sorry.
Then what is wrong?
Because the land manager which was posted by the garden, he did not, because of his fault. There's no appearances made in a trial level. Lordship, after filing the WS, there is no action taken by the defendant side.
Then
Then the suit was allowed by the landed trial court. Then he filed an appeal on certain legal points that schedule was not properly described, schedule of the land. So that was the defect. Secondly, prior to filing the suit, there's a dispute under section 144 CRP. In that case, the learned settlement officer, he described this portion of the suit land as disputed land. And he stated that prior to filing the suit, it was
did you file an application under order 41 rule 27?
that was done at that time.
Hmm?
We filed an appeal only there for the title appeal we filed.
No, in the first appellate state. Did you file an application under order 41
No,
rule
that
20?
was not on record, not filed.
No. Did you file it or not?
It was not, my record says it was not filed.
Find it out. If you have not, then that plea which you are taking cannot be right. Because this is not a case where this court is going to frame any substantial question of. You have not submitted your anything to that effect. The decree has been passed on the facts which all the materials which are already there. The appeal has also been affirmed out there on those facts. You did not, did you raise the issue that your earlier manager did not do anything?
We appellate stated, we have stated that. We prayed that case to be remanded back to the.
No, why will it be remanded? Unless you say that these are the evidence which ought to have been taken into account. You cannot have a right of asking that let it be remanded. No,
That is true, but
there's no, in
Oh.
fact, the questions of law which you are submitting does not arise at all.
only for sake of justice, or because this is the
Justice is there, but the
But then-
justice, but to be lenient on justice,
I understand your thought. Quite rightly.
you come up with a better thing or nothing. You don't have a case. The learned trial court as well as the first appellate court rightly decide. There is the question of remanding it. No question of remanding. You are actually asking for remand under Order 41, Rule 23A. 25.
Or 25.
25 would be keeping the appeal pending and asking for evidence to be taken. But for that, don't you think there is a requirement of filing an Order 41, Rule 27? That these are the evidence which ought to have been taken, which would have changed otherwise the course of events.
Sure.
Then only it could have been done. Nothing was done to that effect. Why should this court in second appeal look into all those things? 3 weeks time granted to the learned counsel appearing on behalf of the appellant for formulating for placing before this court a better set of substantial questions of law, in as much as the substantial questions of law which have been given, which have been proposed, and the additional substantial question of law which have been proposed today do not, in the opinion of this court, constitute a substantial question of law to be formulated in terms of section 104 of the code. So please record.
All right.
Day matters, item 40.
Yes, Mr. Saikya, what are you challenging?
But the issue, but two proceeding one, but the execution proceeding was pending as well as the was also pending between the same party, the degree holder and its defendant. An application was filed to stay the execution of the decree, but that has been rejected, saying that it cannot be said to be a simultaneous process.
Rightly,
That is
you have to obtain an injunction in the suit, not in under order 21, rule 26 or 20.
20.
You can't. So the suit, in that suit, that is only for a brief period, so that you can take the recourse.
That is under 26.
Maybe 26 also, 29 also if you want. The executing court, why will it state unless there is an injunction?
But
Ordinarily, the suit would not lie in view of the provisions of section 47 and order 21, rule 97. Suit won't lie. But if it is a case of fraud, you can very well agitate and get an injunction out there to get a stay out here. There are many judgments of the Supreme Court. You want to what?
also one of the judgments. But there it's first it's after the amendment, it is either of the court can give, because the code is the same. The particular rule mentioned is with regard to the code, not the executive court or the court who is trying the suit. Is the court.
Order 21 is the court wherever it is mentioned is that court only. The executing court. There's no quarrel with that proposal. AIR 1997 SC 210. Nineteen 4 HSC 472. Here it says the learned additional district judge Betul accordingly passed a decree setting aside the award. After 1.5 years, the respondents filed an execution application upon which the appellants came to know about the decree for the first time. Consequently, they filed an application under Section 47 objecting to the execution of the decree on the ground of fraud. The application was dismissed. The writ petition filed by the appellant was dismissed by the High Court with the liberty to execute their rights in an appropriate suit. Consequently, the suit was filed for declaration and to set aside the decree on the ground of collusion and fraud played upon the government. Along with the suit, an application under Order 39, Rule 1 and 2 came to be filed. The application for injunction was dismissed and the appeal has been dismissed by the High Court. Thus, this appeal by special leave. From the above narration of facts, it is seen that there was a valid award passed under the provisions of the Forest Act, and the award came to be set aside on a compromise by the third respondent, though having no authority from the state government. It is an admitted position that when the first suit was filed by them, the state was in possession of the property. On that premise, they sought damages against the state. Under these circumstances, when the state is agitating the right on the ground of fraud and collusion, it is obvious that pending suit, the appellant was entitled to an injunction restraining the respondents from getting the fraudulent decree passed against the state executed. This is your case.
Take it up.
That is the, I've read the entire judgment,
Yes,
nothing
sir.
more.
Sofar Hussain versus Bhubaneswari Devi, 1973. There, the
1973, obviously, because there was, at that point of time, there was a suit permitted. You could have filed the suit. Because in 1976, the amendment came.
Okay.
Therefore, now you can't file the suit. See, at that point of time, a suit was filed. You could have certain aspects were outside the scope of a proceedings under Order 21, Rule 97 to 103. In those suits, then you could have very well filed a suit at that point of time. But 1976 amendment came whereby you are barred from filing the suit, and there is also an amendment to Section 47. But if it is a case of a fraud or collusion, then you can very well file a suit. There is no bar. So that is why this judgment has come.
suit has been filed on the grounds of the fraud.
Absolutely. So you need to get an injunction to restrain from executing the decree. Not in the proceedings under the execution court. Because the executing court cannot. How can it stay? Tell me. Unless you are satisfied to show that it can, it is not an executable decree, you cannot. It would go within. Now, if the court stays it pending a suit, then how are you going to finish off any suits? Every time a decree is being passed, you file another suit on the ground of fraud. And that suit, you know how long it will take. This is the best way out. So you need to get an injunction from there. Then only it will take place. What Tuesday? We have spent about 15 minutes here. These type of matters do not require Tuesday business. Tuesday too doesn't arise for this type of. Yes, what do you have to say, Mr.
My
Nanda?
lord, actually, the decree, my lord, that was passed, my lord, as far back, my lord, on 1980 and 1994, my lord.
Hmm.
And against that judgment decree passed by the trial court, my lord, first appeal was preferred, first appeal was also defeated. Here they have lost. Then the second appeal was preferred, second appeal also they lost. Now they have come.
Now they are saying that there is a suit filed.
And in the second appeal, my lord, the judgment letter was directed to vacate their to premises within a period of 6 months, my lord. That also they have not complied with, my lord. It is a case of a violation of the order of this honorable court, my lord. Over and above, they have also filed their objection against the execution of the decree, and that objection, that matter is now pending for final hearing, my lord. That is the order passed by the municipal by the executive court, my lord. That you will also find last page, my lord, page 41. Page 39 2020 for final hearing of the objection filed by the judgment debtor, my lord. The petition which has been by this order has been the petition filed by the judgment debtor for stay of the execution of the decree, my lord. That petition has been rejected. Now the matter will be hard on the objection filed by them, my lord.
Hello.
Objection would be.
Let us dismiss it.
What?
There is a delay.
My lord.
Delay to the execution.
No.
By them.
Yes, my lord. Because of the actually there's the
So we impose costs.
my lord. No. After the decree was passed, that we have
Suit was
not been
filed.
able to.
Initial suit was filed when?
They have to go to my lord.
94.
94.
Oh no, 75. 75. 75 plus here, 49 years. 49 into 30. How much? 30,000? 49 into 30,000?
1 lakh.
No, 49 into 30,000. 30,000 per year.
Sorry.
That should be the cost. 15 lakhs. 14 lakhs. Cost.
In the original suit, whether you were not the party.
Not necessary.
But the execution petition was filed after 11 years.
14 lakhs. This is an application under Article 227 of the Constitution challenging the order dated, this order 25/8/2022.
Yes, my lord.
The order dated 25/8/2022 passed by the learned executing court, that is the court of the learned Munsif at Naharpati, in title execution case number 5/2019, whereby the application filed by the petitioners who were the judgment debtor were rejected. This court have heard Mr. P.J. Saikia, the learned senior counsel, assisted by Mr. R.S. Mishra, appearing on behalf of the petitioner, and Mr. N.C. Das, the learned senior counsel, assisted by Toronto for the respondent. From the materials on record, it reveals that the decree holder, as plaintiff, had instituted a suit being title suit number 23 of 1975.
It was decreed on 1990.
The court of the Munchip, Dibrugarh, my lord.
Against one Tonkeswar Dwara for recovery of a sum of rupees 10,400
No, that was suit for ejectment, my lord.
on, okay, had filed the suit. Where is the suit? Okay. I filed a suit.
Case number,
I
registry of
filed a suit against one Tonkeso Dwara for recovery of khas possession
First point.
of a premises
Should premises, my lord.
which have been described in the schedule to the claim of the said suit. The said suit was decreed on 19/8/1994.
Negative.
Thereupon, who filed the first appeal?
It's a judgment letter, my lord.
Tonkeso Dwara.
No, ma'am. During the pendency, he died, Professor died. They have
And-
substituted only his wife, not the legal, other legal heir.
Necessary.
Wife.
Why?
We are not the
It is relevant to mention that during the pendency of the said suit, the said Tonkeso Dwara expired and he was substituted by his wife,
My wife is Srimati Maisana Dwara.
namely,
Maisana Dwara. My
where do I
Namely,
get somewhere? Mainu Dwara.
Right.
No, Mainu, no,
Maisana. Maithana.
Maitona Dwara.
page 16.
Thereupon, the legal representatives of late Tonkeso Dwara, who were substituted, being aggrieved, preferred an appeal
Title appeal number 3 of 1994, my lord.
before the court of the court, which court? Before the first appellate
First
court,
appellate court.
which was registered and numbered as title appeal number
15 of 1994, my lord.
15/1994. The said appeal was dismissed by the judgment and decree dated 31/5/1995. Thereupon, a second appeal was filed in the year 1995, and the same was dismissed on 31/10/2000.
Here is a direction for directing the judgment to vacate the premises within a period of 6 months, my lord.
Thereupon, the execution application was filed on 16/6/2011. It may be relevant to mention that in the decree so passed by this court in the second appeal, being RSA number
128 over 1995, my lord.
1995, this court categorically directed the appellant to vacate the decretal property
within a period of 6 months, my lord. from the date.
within a period of 6 months. Who are these people, the Dwaras now?
He's a son, my lord.
Huh?
Son.
The grandson.
Grandsons of heir.
Son was not implicated in this.
Okay. You are the grandsons.
I'm the grandson.
Okay. Pursuant to the filing of the execution application in the year 2011, in 2012, the grandsons of the original defendant, that is late Tonkeswar Dwara, filed a suit which was registered and numbered as title suit number 49/2012 for a declaration that the decree obtained by the defendant on 19/8/1994 in title suit number 23/1975 was null and void, illegal, inoperative, and unexecutable due to fraud and misrepresentation. And the defendant had no right, title, and interest to execute the said decree. Semicolon. As well as also for a declaration that the plaintiffs or their dependents and persons under them are not liable to be evicted from the suit premises described in the said decree, along with perpetual injunction. And stay of the execution proceedings, being title execution case number 11/2011. The said suit subsequently was renumbered as title suit number 4/2022. In view of the fact that the said suit was transferred to the court of the Munsif, Naharkotia, in view of the amendment to the Bengal Agra Civil Code Act 1887, thereby enhancing the pecuniary jurisdiction of the court. It is also relevant to take note of that in the said application, in the said execution proceeding, an application was filed under Order 21, Rule 29 of the Code of Civil Procedure 1908 prior to filing of the suit by the petitioners herein, which aspect of the matter would be apparent from a perusal of the relief sought for in the suit filed by the petitioners. The said application was rejected by the order dated 28/5/2022, and it is under such circumstances that present application has been filed. That is okay. Mr. P.T. Saikya, the learned senior counsel appearing on behalf of the petitioner, submitted that in view of the provisions of Order 21, Rule 29, the learned of the court, the learned executing court ought to have state the decree in view of the pendency of title suit number
4 of it.
4, earlier number was different, no?
49 of 12.
Title suit number 49/2012, which was subsequently renumbered as title suit number 4/2022. He submitted that if such an order is not passed, the suit which had been filed by the petitioners, being title suit number 4/2022, would become infructuous. On the other hand, Mr. N.C. Das, the learned senior counsel, appearing on behalf of the respondent, submitted that the suit was filed against the grandfather of the petitioner. The grandfather of the petitioner duly contested the suit during his lifetime. And after the death of the grandfather of the petitioner, their grandmother was duly substituted. Thereupon, an appeal was, after the decree was passed in the year on 19/8/1994, an appeal was prepared by whom? Who prepared the appeal? You have the appellate papers
By the grandmother. By the grandmother. My son.
by the
My son,
grandmother.
my son.
Was prepared by the grandmother
My son.
of the petitioner, which was registered and numbered as so and so. Thereupon, the said appeal was dismissed by an order dated 31/5/1995. Then who filed the second appeal?
Well,
I
second
don't
by
think
by the
she's-
same Milo. Grandmother Milo.
And she was alive till then.
Grandmother.
She's still alive.
Second appeal was filed by the wife, by the grandmother Milo.
And then,
That
She is-
also dismissed Milo.
okay. Good. Thereupon, the second appeal was also filed by the grandmother of the plaintiff, of the petitioner, which was dismissed by this court on 31/10/2000. The petitioners herein claim their right from their grandmother and the grandfather.
We are claiming.
That is his submission.
We are independent. Yeah.
That the petitioners claim their right from their grandmother and the grandfather and had no independent right. And as such, the filing of the suit was not at all, was an attempt by which the was an attempt by which was an attempt to deprive the decree holder of the fruits of the decree. He further submitted that a perusal of the plaint would also show that the execution proceedings was initiated much earlier than the suit which was being filed. And as such, the learned first executing court committed no error in passing the order. Mr. P.T. Saikia, the learned senior counsel, rejoining to his earlier submissions, submitted that the petitioners herein have claimed an independent right over the decretal property and not on the basis of. Are you sure to make that submission? Yes, sir.
Diety was granted to the father of the diety pata was granted to the father of the petitioner in the year 1990,
Father of the petitioner.
who was not a party
When?
in 1990.
95. During the pendency of the suit. Even after the first and second appellate degree.
The suit was dismissed from
Mr. Saikia, if you make that submission, I will reply, which will have a disastrous consequence upon you.
there state that
Okay, then let me deal with that also. Because this is a decree which needs to be executed within 3 months. Huh? Mr. P.J. Saikia, the learned senior counsel, rejoining to his earlier submission, submitted that the plaintiffs, oblique the petitioner, do not claim their right from their grandfather or the grandmother, but claims independent rights on the basis of a rayati khatiyan being issued in favor of the father of the petitioner, the father of the petitioner, in the year
on 12/12/1990.
on 12/12/1995. This court had duly heard the learned counsels for the parties and given an anxious consideration to their respective submissions. From the materials on record, it is apparent that a lawful decree was passed by the courts against the grandfather and the grandmother of the plaintiffs, of the petitioners, of the petitioners herein, in respect to the suit premises, which was a quarter. It's a quarter, no? Situated at Old Stuff Line at Nahargotia Tea Estate. Though it has been submitted by the learned counsel, senior counsel appearing on behalf of the petitioners, that the petitioners claim their independent right on the basis of a khatiyan being issued. But the issuance of a khatiyan would only be a khatiyan in respect to the land and not to the scheduled premises of the suit. Further to that, the said khatiyan was issued during the pendency of the said suit, and as such, any devolvement of the right during the pendency of the suit would be only subject to the further proceedings of the said suit, which was decreed in favor of the respondent herein. This court also finds relevant to take note of that the learned trial court, the learned executive court, was completely justified in coming to a finding that the provisions of Order 21, Rule 29 could not have been applied to the facts of the case, taking into account that the suit which was filed was subsequent to the decree, subsequent to the execution application which was filed. And as such, the said provision would not be applicable. Under such circumstances, it is the opinion of this court that the impugned judgment and order dated (25 8 2022) do not call for any interference. Inasmuch as there is a lawful decree which is being passed in favor of the respondent herein, the decree holder, and it is seen that the suit was filed in the year 1975, and as on date, almost 49 years have passed by, and the decree holder is yet to enjoy the fruits of the said decree. Consequently, the instant petition stands dismissed, thereby directing the learned trial court, learned executing court, to proceed with the decree in accordance with law. Taking into account that the parties are duly represented, this court vacates the interim order, the order dated 18/11/2022, passed by this court, and directs the parties to appear before the learned trial court on 25/2024 for further proceedings for the executing court.
Always true.
The observation that the lawful decree, etc., that will not affect
Absolutely no.
interest.
Yeah.
That is
I
yet to be
therefore say, don't make this. You should have withdrawn. Next. This is basically required, otherwise people will lose trust in the civility. I say. If that proceeding, the second proceedings would have been before this court, which is yet to be decided, I would have immediately direct. You can't do that. Yes, what is this?
Is a transfer application for transfer of title to matrimonial.
Where do you stay?
I said Tinsukia,
Tinsukia. And the transfer is made in?
from Chittagong to the district judge Tinsukia.
So?
In the meantime, I filed a domestic violence case in Tinsukia, wherein the respondent is appearing and contesting.
So what? You file it subsequently. It is not pending earlier. What do you do?
I do nothing. I have no income. In the meantime, in the domestic violence case, interim maintenance was directed to be given, which they have not paid as yet.
Forget it. They are not paying. Why will they pay? They won't pay you.
I'm the
You
wife.
don't know. You know what to do out there if they don't pay. I'm not on that. What is this business out there in Tinsukia you want to do? You don't do anything.
I was a primary teacher, but after our marriage, I was not allowed to continue
Where?
at this year.
Marriage took place where?
This 2019 December 1/12.
Where?
At Chitsa.
Marriage at Sipsagar. Last resided at Sipsagar.
But during Jamai Sati, when I went to my parental house at Tinsukia, I was the respondent did not contact me. And when I
And what is the stage of the proceeding?
with domestic violence,
No. Are we? Do we have anything to do with the
Right,
domestic
right.
violence?
title to matrimony at the stadium.
No. What was the proceeding? Yes, madam. What was the stage?
Yeah, I am staying in Shipsagar, madam.
Huh?
Shipsagar.
What was the stage?
It says that I have not received any instruction. Earlier occasion, the honorable court is directed to appear.
No. What was the stage?
I appeared through my counsel, and
Mediation
thereafter I
center.
filed this transfer petition.
So you appear through the council and file your written statement there. It is before, not before the family court. It is before the district judge. How does it relevant?
I have no
Why
one to
should we
I have-
transfer this?
I have a child of 2.5 years.
They are going to
No
pay
one to
3,500 per month.
Yes, madam.
You are going to pay now whenever she appears.
I have no instruction. He's supposed to be paid, madam. The honorable court is directed to appear him the mediation center, but she is not appeared. I want to bring her back, but he is not compromised.
This is a suit for the resolution of marriage. They filed a petition.
There was a minor son also, minor but he did not
So,
compromise.
You want to compromise?
Yes, my lord.
Then withdraw this case with liberty. Anyway,
Then,
On the last date, they have stated that they are going to withdraw. But
Then withdraw. We do one thing. We fix this matter after 1 month. I vacate that order to that extent. Thereby, if you want to withdraw, you can withdraw.
yes, my lord.
Okay? Because of a stay, you can't withdraw. We vacate that order or modify that order to that. Ms. So appearing on behalf of the respondent submits that the respondent does not wish to proceed with the said divorce proceedings, but on account of the order of stay being passed by this court, the order of stay passed by this court on 25/1/2023 and subsequently the same being continued. The petitioner, the respondent is not in a position to file appropriate application seeking withdrawal of the said divorce proceedings. Taking into account the above, this court modifies the order dated 25/1/2023 passed by this court. Thereby, permitting the respondent herein to file appropriate application before the learned district judge Sibsagar,
Yes.
before whom title suit matrimonial number 118/2022 is pending. And if such application is filed, permit withdrawal of the said proceedings. This court, the instant proceeding is next fixed on 3rd of June 2024 for an update.
खाली होता है.
Apply.
Yes, madam. Now you want to do what?
I want to transfer the
Transfer from?
transfer from Kirang Kazolgaon civil Kazolgaon Kirang to any competent court in the district of Kolkata, madam.
Why?
The petitioner, the petitioner can kidney patient.
Huh?
The petitioner is a kidney patient. He is a regular dialysis.
What case you have filed?
I have filed a transfer petition for transfer.
No. Who filed the case?
The respondent has filed the
Case for what?
title.
Specific purpose.
Specific purpose.
So why do you want the transfer?
Because the petitioner is unable to appear before the court.
Why is the petitioner required to appear before the court? Tell me. It's a suit. Lawyer is there. Lawyer will appear. Even if I transfer it to Kolkata, then also the lawyer will appear.
But he is presently deciding in Kolkata.
Who?
But he is
Okay,
more than
so what? How does it matter? It is the lawyer who will appear. And you being a case, at best, it may be a case by which you are going to give your evidence. Let us help you. You can very well file an application for issuance of a commission if you are not in a position to go there. The court will issue a commission. I'll give you the liberty if you are not well. Nothing to it. It's the suit. The lawyer is going to appear.
But he is more than 70 years.
Huh?
He is more than 70 years old.
Understood. She doesn't need to go. The lawyer is going to appear. Is it a divorce case? No. So, the pure and simple civil suit, the lawyer is going to appear. And if necessary, you can very well file an application for issuance of a commission. You will be only required for your cross-examination. Nothing more than that. So, at that point of time, you will be at liberty to file an application if you are not well for issuance of a commission, your lawyer. And the commission will go. You will have no objection.
No.
You won't object.
No.
Chalo. Huh? I'll also record to the effect that the respondent shall not object.
Yes.
To that application. This is an application under Section 24 of the Code of Civil Procedure 1908 for transfer of the proceedings of title suit number 30/2022 along with the connected miscellaneous applications pending in the court of the civil judge Kazolgaon, Sirang, to any court in the district of Borpeta having competence to adjudicate the dispute. This court have perused the copy of the plaint which shows that the suit so filed, being title suit number 30/2022, is a suit for specific performance of an agreement for sale dated 6/6/2020 and other consequential reliefs in respect to a plot of land situated in the district of Sirang, BTR, Assam. This court inquired with the learned counsel appearing on behalf of the petitioner as to why the petitioner, who is the defendant, seeks the withdrawal of the said suit to Gorpeta. The learned counsel submitted that the petitioner, who is the defendant, is a 70-year-old lady and has kidney ailments. This court finds it relevant to take note of that in the said suit, the petitioner oblique the defendant is not required to be present in person. And the said suit can very well be decided by the, can very well be adjudicated by representative counsel, adjudicated. No. The said suit, in the said suit, the petitioner would be represented by her counsel. This court also finds it very pertinent to take note of that the appearance of the petitioner may only be required at the stage of her cross-examination. During such an exigency, if there is any exigency, in the opinion of this court, in the opinion of this court, the petitioner would be well advised to file appropriate application seeking issuance of permission for the purpose of her cross-examination at her place of residence. This court had also inquired with the learned counsel appearing on behalf of the respondent herein, who are the plaintiffs, as to whether they would object to such application. And the learned counsel on instruction submits that that the plaintiffs would not object if the said application is duly supported by medical documents. This court also finds it very relevant to take note of that a suit is for specific performance in respect to a plot of land which is in the district of Tirang. And if the said suit is decreed, it will involve execution of the decree to registration of the deed of sale. It would lead to various complications if the said suit is transferred outside the district of Sirang. Under such circumstances, this court is not inclined to exercise the powers under Section 24 of the Code of Civil Procedure 1908 in the instant proceeding, for which the instant proceeding stands dismissed for not dismissed. Next. This court also takes note of that on 3/5/2023, The further proceedings of title suit number 30/2022 pending before the court of the learned civil judge Kajalgaon Sirang was stayed. Taking into account the order passed herein above, the said stay order is vacated. And as the parties are represented before this court, the parties are directed to appear through their counsels before the learned trial court on 25/2024 for further proceedings of title suit number 30/2022. আমি ভালকে মাৰিব দেই, slowly কৈ আছো, very slow.
Maybe a lot.
Yes.
Because here office note says lordship, two persons lordship already clear has the effect lordship, but 2 persons lordship they although original staff lordship they have effect. How lordship?
Yes, what is this amendment you sought for?
Amendment lordship I sought for lordship. That is
Where is your application?
yes, application lordship is 45 lordship.
What was the stage?
Stage lordship, now the practice occurs the photo is already decided lordship. Now it is appellate stage lordship.
Huh?
In appellate stage lordship, I lordship filed petition.
You want to amend your written statement
Yes, lordship. So yes, lordship.
in the appellate stage?
Yes, lordship. That direction was called for lordship.
Huh?
That is the order was called for lordship. The practice was so vital lordship. Appellate lordship, they want to partition lordship some land lordship. And lordship, the land is actually lordship muted in my name lordship, my mother's name, my predecessor in lordship.
Why didn't you inform about this thing earlier? Why didn't
Yes,
you
lordship.
mention it in your plain or your written statement earlier?
Lordship, it is the issue lordship. It is actually the document lordship, the pata. So that was given to the hand over to the council lordship, written council lordship.
Which council?
Council in which depending us lordship.
Mr. Counsel, you know that this court does not like the blaming of other counsel.
That is correct.
So don't make all these things unless you have filed an application before the bar council against it. Have you done that?
So that is not done.
Then we won't.
Whether it is appellate stage, but the fact is so vital lordship. So your main issue is the main and one document. If that document, the amendment is based paragraph 7 lordship.
Now, your ground of appeal. Did you take that ground about your lawyer connivance with the plaintiff? Did you take that ground?
In actually, they have
In
filed
your
in
ground of
petition.
appeal, did you take that ground?
That is also not taken, but they only filed the separate miscase. This separate I was filed.
I'm not on that. I'm asking you. In the appeal, in the memo of appeal, did you take that ground that your lawyer had acted in connivance with the plaintiffs?
The memo of appeal is not done. Separate petition is filed.
Your entire case is false. The person who filed the appeal now knew about it when he got the judgment of the trial court. That these are the documents which court was there. Kindly listen, these are the documents which were there, which was not placed, and the lawyer made this mistake, although I have given those documents. At the time of filing the memo of appeal, you must have come to know. And at that point of time also, did you raise that issue?
The lawyer who conducted the first appeal, lordship,
Not raised.
Not
the
raised.
inspection was also not with him. lordship.
You cannot point out this. No.
So lordship then lordship may humble prayer lordship. Lordship, if they want lordship, they may lordship amend their appeal memo of appeal lordship, that liberty was given
Amend the memo of appeal for what?
for
If they want to amend this resolution, they have to insert this abatement in the memo of appeal.
Yes.
If they want to take a tax this bill, in the memo of appeal, they can take. That liberty will be different. Memo of appeal, they can.
Under what provision? Tell me. If you tell me that provision, I will allow it.
That's liberty law.
No, no liberty. There is a provision. Tell me. Then don't make the submission. There is a judgment of the Supreme Court also. Tell me. You can't file petitions and just throw it in the face of the court. Because you can't bring certain things without amending the memo of appeal. The memo of appeal is to be amended. You see the CPC categorically mentions how it is a memo of appeal has to be there. See this. Finally, see Order 41, Rule 3.3. This is an application under Article 2 to 7 of the Constitution challenging the order dated 19/10/2022 passed in Mize case number 19/2021 arising out of title appeal number 3/2020, whereby the applications filed for amendment of the written statement in the appellate stage was rejected by the learned trial first appellate court holding the said application was not maintainable. It was, however, mentioned in the said order that the appellant, who is the petitioner herein, can take plea of adducing additional evidence as per the provisions of Order 41, Rule 27 of the Code of Civil Procedure 1908. Or raise the ground in the memorandum of appeal by seeking necessary amendment in the memo of appeal. In the opinion of this court, the said order does not require any interference inasmuch as interference in view of the reasons to assign in the impugned order, and further to that, without amending the memo of appeal, the grounds of objection in the memo of appeal, in terms with Order 41, Rule 3(3) of the Code, these additional, the grounds for filing the application under Order 6, Rule 17 of the Code could not at all have been entertained. Accordingly, the instant petition therefore stands dismissed. The order dated 4/4/2023 stands vacated, and the learned trial court, the first appellate court, that is the court of the civil judge Gwalpara, shall proceed with the adjudication of title appeal number 3/2020 in accordance with law. As the parties are duly represented before this court directs the parties to appear before the learned first appellate court, that is the court of the civil judge Gwalpara, on 25/2024 for further proceedings of the appeal.
One more only, kindly one more.
Huh?
This dismissal of the may not be effect to the other ordinary remedy laws if they have.
What remedies? Other remedies? You have been granted the leave.
Yes,
Full stop. Before parting with the records, this court makes it clear. Next paragraph. That the dismissal of the instant application shall not preclude the rights of the petitioners who are the appellants in the said appeal. The petitioners herein who are the appellants in the said appeal, to take the benefit of the liberty so given in the impugned order.
44.
Yes, Mr. Sen, where do you want to go?
My lord, before I start this proceeding, my lord,
Huh?
before I start my submission, my lord, I am told by my friend that my lord Justice P.K. Dekam retired, has
Yes?
his last expired,
P.K. Soikia.
P.K. Dekam.
He's very much there.
My lord, I have been
Don't
told-
make all this type thing.
My lord, my lord, in Delhi, my lord,
I know that. Then how does it matter with this proceeding? He has any relation?
Since, my lord, I have heard.
There is no relevance. Now come to the facts.
Yes, yes,
Yes.
my lord, what has happened in
Mayong
this
to
case?
Kamrup.
Yes, from Kamrup to my lord, I am my lord appearing as legal aid counsel in this case. My lord, wife has filed this transfer application, sir, for transfer of my lord divorce case, which has been filed by a friend. My lord, for declaration of
From here to Murigaon.
my
When to Murigaon.
Right.
Mayong is nearby from here.
my lord, because my lord,
Huh?
she is my lord there at my lord Madigaon.
She's not. She's at Mayong.
Oh, well,
Yes, her address is at Mayong. See, you have not read it properly.
my lord,
Mayong is nearer to the family court than to
my
Murigaon.
lord, but I am told, my lord,
You are not
That-
told. I know. I have visited.
my lord,
You are nothing to be told.
I am-
Nothing arise. It is nearby.
no, my lord,
She will, you see, from here to Mayong will take, yes, Mr. J. Roy, you keep on visiting Mayong. Isn't it nearer?
Yeah.
From here to Mayong is nearer than from going from Mayong to Murigaon.
But
Then,
she is my lord illiterate, my lord, she doesn't know the my lord the family.
then you
code.
want the court should go to her house.
No, my lord,
Then-
that is not the case, my lord. My lord, she is my lord. She is not given any maintenance, my lord. She is not having any money to travel.
You
all
say
the
that
way
she is illiterate. She has signed out.
from- But she doesn't know, my lord.
How to read or write English.
No, my lord. She is not familiar to the my lord Guwahati city and my lord the Guwahati. Rather, he likes to my lord proceed the case, my lord, in the Murigaon because his paternal house is there, my lord, and that is my lord familiar to her, my lord. For my lord, that reason, my lord, he said, my lord, that it be transferred from here to Morigaon.
I think this is a fit case for dismissal.
But because he is not, my lord, having any money, my lord.
You must ask for money. Yeah. Go and ask for money.
Let them pay my traveling expenses and all.
Why? Why should this court pass an order when Mayong is nearby to the principal court?
That is true, my lord.
Yeah.
What is
Mr. Sen, what do you want? Should I dismiss it? I'm not going to transfer this. Nothing to it.
My lord, one fact, my lord, which I would like to point out. He has filed a, my lord, DB case in Chief Judicial Magistrate, my lord, before Morigaon.
Very well.
He is appearing. my
You
lord,
file an application there. Here. When I sit in the criminal bench. And then we'll transfer the DV case out there.
He is
Don't worry.
appearing there, my lord, in the case.
Whatever may be.
In the
Leho.
Morigaon, my lord.
This is an application under section 24 of the Code of Civil Procedure 1908 seeking transfer of FC bracket civil number 1141/2023 pending before the court of the learned Principal Judge Family Court, Kamrup Metro at Guwahati, to the court of the District and Session Judge Morigaon. This court have duly taken note of that the petitioner herein is a resident of Mayong. The distance from Mayong to Guwahati is much nearer than from Mayong to Morigaon. The difficulties which have been stated in the said application does not inspire the confidence of this court. Accordingly, the instant petition, accordingly, this court is not inclined to exercise its jurisdiction under section 24 of the Code of Civil Procedure 1908 in the instant proceedings, for which the instant proceeding stands dismissed. Taking into account that the parties are duly represented, the further proceedings, the order dated 7/2/2024 passed by this court is vacated. The petitioner, the parties are directed to appear before the learned Principal Judge Family Court, Kamrup Metro at Guwahati on 5/6/2024. It is made clear that on the said date, the petitioner shall file her written statement without fail.
Order is at page 50.
What is wrong with the order?
My lord, we paid for that, the original buyer's copy is with the defendant.
Did you mention in your plaint?
No, no.
That is the requirement of orders
That
for
is
7
only-
rule
That is the
14.
only observation, my lord, where the.
No, not only that. The defendants have also denied possession of that document.
That's it.
Then how can their court direct under order 11/114 if when they deny the possession? Then the next course of events would be, if the defendants have denied, then You are to give secondary evidence.
That is my prayer.
That is what you have to do. I can't give you that. That is not your prayer. Yeah. No, in that proceeding. Your proceedings was under order 11 rule 14.
Rule 40, my lord, but
Then
lordship has it.
you file a separate application for 65. You withdraw this thing. Don't press this, but you will file, I'll grant you the liberty for that. I think that is a better. Because if I say anything, it will may affect. The instant petition filed under Article 227 of the Constitution is challenging the order dated 1/11/2022 passed in Mirza case number 98/2019 arising out of money suit number 216/2015, whereby the application filed by the petitioner, who were the plaintiff in the suit, under Order 11 Rule 14, read with Section 151 of the Code, was rejected. This court had perused the impugned order dated 1/11/2022, wherein the learned trial court, that is the court of the civil judge number 3 Kamrup Petro at Guwahati, had rejected the said application on the ground that the petitioner, who is the plaintiff, did not mention in the plaint, as is required under Order 7 Rule 14(3), as to under whose possession the said document under whose possession the legal notice, it's the legal notice, dated 5/12/2014 was
And invoices.
Was under whose possession and custody the legal notice dated 5/12/2014. The learned first trial court also observed that the defendant have denied that the said legal notice dated 5/12/2014 was not in their possession, as would be also apparent from the impugned order. Taking into account the above, in the opinion of this court, it cannot be said that the learned trial court had committed any jurisdictional error in passing the impugned order dated 1/11/2022, insofar as rejecting the application for directing the respondent, the respondents herein, who are the defendants in the suit, to produce the legal notice dated 5/12/2014. Be that as it may, it is also seen that from the said application, which have been filed under Order 11 Rule 14, there is an alternative prayer that in the circumstance the defendant failed to produce the said legal notice dated 5/12/2014, the plaintiff may be permitted to adduce secondary evidence. This court duly takes note of that in the order dated 1/11/2022, the learned trial court did not decide the said aspect of the matter. Rather, only have noted the submission made by the respondent herein, who are the defendants, that there is no application filed under Section 65 of the Indian Evidence Act 1872. Taking into account the above, this court is of the opinion that the order dated 1/11/2022 does not require any interference. Be that as it may, the petitioner herein, who is the plaintiff, would be at liberty to file an appropriate application in terms with Section 65 of the Indian Evidence Act 1872 for the purpose of adducing the legal notice dated 5/12/2014 as secondary evidence. If such application is filed, the learned trial court shall duly consider the same without being influenced by the order dated 1/12/2022. With the above, the instant petition stands disposed. The interim order dated 21/8/2023 passed in this court proceeding stands vacated, and as the parties are duly represented, the parties are directed to appear before the learned trial court on 25/2000.
Date is there, my lord. 1/6, I think, takes place, the time.
On 1/6 are directed to appear before the learned trial court on 1/6/2000. Not 1/6 is closed. 1/6 is Saturday.
1/6,
Yes,
I
my lord.
Saturday.
On 1/6/2024, on which date the petitioner herein would be at liberty to file the application under Section 65 of the Indian Evidence.
Only one thing, my lord. Legal notice along with buyer's copy of invoices. The two documents, my lord. One is legal notice and other is the buyer copy of invoices. Lordship may see page 53, last part. Consider buyer's copy of invoices and the legal, that's the two documents. I've annexed all those buyer's copy of invoices in the application of.
Invoices.
Buyer's copy.
Buyer's copy of the as mentioned in Annexure A to the application filed under Order 11 Rule.
Obliged.
Yes. What is this matter?
Rejection of amendment application. Technically, I have to be fair to the court. Because in the amendment application,
There is no mention what is the amendment.
but the only thing is that if Lord, I would say.
Let's see the suit. Did the state of Assam file a written statement?
Yes, the BTC authority.
State of Assam filed a written statement.
State of Assam, my lord, was to be represented by the finance department. That is.
They did file the written statement. Has it got ex parte against it?
My lord, perhaps not.
If it's not, then why didn't you file? Indeed. That is the only way out.
Otherwise, my lord,
Otherwise, there is no
no,
way
no,
out.
I cannot help. Only my lord, I will be seeking my lord's interference to the extent. Because in the impugned order, my lord will find that the learned trial court has commented on merit. That may affect our defense. To that extent, if lordship makes an observation that in the impugned order, the observations made by the trial court
Shall be only limited to the what you call the shall only be limited to the adjudication of the application under Order 6 Rule 17 and shall not influence it.
only that. Only that.
Why don't you get somebody else to appear
Yes,
in this
my
matter?
lord, I am appearing on behalf of senior counsel P. Sir. Yeah.
No. Ask somebody else to appear because you see, you are a finance counsel.
Yes, otherwise.
You will have a problem the
Yes,
moment you are
yes,
appearing out here and then to say something else. Get hold of somebody else. Anybody ABCD.
So people kindly keep this statement
Yes.
for some time. Yes.
Get hold of some ABCD. Although it's a proxy, it's a different thing. But get hold of her because tomorrow, because that day I thought about it when the matter came up. You have reasonable things to say, but you can't say it by in this manner.
It was other day after that I must
And not
admit
only
it.
that, there could have, as you could see from the impugned order, it says something to the effect that it amounts to withdrawing of an admission.
That means, to that extent, lordship may kindly interfere.
No, I am not going to interfere. If it is amounts to withdrawing of an admission, if you have already stated out there, and that amounts to a withdrawing of an admission, then obviously the trial court was justified.
Trial court nonetheless might not have
You
commented-
no, you'll withdraw the petition out here and only say that should not prejudice you in the trial. That's all. Don't say anything more than that. The moment you say about that, I'll have to record that the withdrawal of the admissions cannot be permitted.
I am not on that. My
It will have far-reaching consequences.
our limited submission will be that if lordship interferes, lordship will not interfere in toto with regard to the impugned order. That much. Number one. Number two, all merit, whatever has been commented, that will not influence the trial. Only that much.
Therefore, you have to withdraw the would not because the learned trial court had come to a finding that the what you want to bring in is touching on the admission. Then I'll have to say something on that. The moment I say something on that, it will have a far-reaching consequence. So the best way is to withdraw and make a submission. Then look here that the observations so made shall only be restricted to Order 6 Rule 7. And we will take it as if it is withdrawn at the time of motion. I did not look into the file. But if you say on that, and I have to say, I'll have to say that yes, the trial court was justified.
Lordship will have to enter. Yes.
Then you will be
Yes,
in more trouble.
Yes.
The only way out is the finance. The finance can very well bring in by filing a written statement, or even if it has gone ex parte to bring in and say that whatever may be, that these are the reasons. You can bring in. Once you bring in, because whatever may be, these I think are all these bench 4 matters which came up before this court, wherein this court said that within 2 months or 6 months you dispose of these use and pay. I think these and where the Boroland territorial, because there was one memorandum done by the Boroland Territorial Council at that point of time saying that yes, these people are and we are looking into it and we'll pay the money. And on the basis thereof, they have come before this court, and many of these courts have passed an order to the effect that in view of that, you look into it within 2 months or 3 months and dispose it off. And now they have, in view of this investigation being carried out, this must have happened. So it seems to be a continuation from the bench 4 to here. Yeah. Now go get hold of another person who is going
Some
to.
contractors are wise enough to file a civil suit
Huh?
out there. Some contractors, they were wise enough to file a money suit out there rather than filing it.
So, my lord, has fallen from your lordship, but any finance doesn't file it, assume it for the moment. then
Then you are in trouble.
no, my lord, then also the BCC authorities are not precluded from filing any subsequent amendment application on different states. It's different states of sector law. So that is not what the order is to. I can see because here the only issue was there the amendment was there. What is required to be amended? It was not specifically stated. It is absolutely right. Only to that extent. To that extent, even I cannot justify. I have to be there. So that is the limited issue. That the amendment application itself was there.
No, there is another reason given. See, I'll do it. See the reasons given. There is another reason given. That this would amount to whatever they are saying would amount to taking away the admission.
Yes.
See, I've seen that.
Yes.
Then how do you take care of that? See, page 69. This court's
Yes, yes.
discretion to grant amendment lies on two. Firstly, no injustice should be done to the other side. Secondly, the amendment must be necessary for the purpose of redress. However, to balance the interest in pursuit of doing the justice, the proviso clearly mentioned the amendment shall be allowed after the trial have commenced in spite of so and so. Then you see here, page 71. Here, in absence of any proposed amendment, the grounds shown by the defendant here are not sufficient to allow any amendment in the written statement as there is no new change in facts, circumstances which needs to be introduced. Rather, the amendment may divest the opposite party of any advantage which it has secured as a result of admission by the AR. Secondly, the amendment sought by the petitioner on the ground of original sanction order by so and other grounds are fake and does not exist is not necessary for the purpose of real determination of so and so. So I have to interfere with this. Then how do you do that?
What the issues have been discussed.
Then
So therefore, if my lord doesn't interfere with the imperial order to the extent of the parameters set out in order, because my lord, that amendment application was totally my lord, it was a hopscotch. My lord, it was not drafted correctly. To that extent of the rest of the observations which not affect the trial. If that much observation is there. Otherwise, my lord, documents are there which can be brought.
anyways, get hold of another person. Well, what is the name? Not necessary to get hold of him. What is his name? Who is going to?
Lordship may record the name of
Or give whoever's name it is. Let me dispose it.
Ranjit Mishahari.
Whoever name.
No, he is the standing counsel PTC. He is on record.
Anyways, whoever's name you want to give it to. Same order will be there for all. Beleg.
Yes, my lord.
Okay. And number kita bolli.
From item 55 to 67 in the supplementary list.
The instant application under Article 2 to 7 of the Constitution has been filed by the petitioner, who is the defendant in the suit. Defendant number 1 in the suit.
The 2, 3, and 4.
Defendant number?
2, 3, and 4. One is finance.
No. One is performer. Performer is finance.
Performer is finance.
Then,
No.
Where is the plane? Yes.
Plain plausible find at page 22.
Filed by the
Defendant number 2, 3, and 4.
filed by the defendant number 2, 3, and 4 in the suit. Petitioners,
My lord.
Were the defendant number 2, 3, and 4 in the suit. Whereby an application was filed seeking amendment of the plaintiff of the written statement. The said application, upon being filed, to the said application, written objections were filed by the plaintiff taking various grounds to the effect that the said application seeking amendment ought not to be allowed. The learned trial court, that is the court of the civil judge Sirang, Kazalgaon, the said application was registered at Miss J case number 27/2023. Line to this is an application under Article 227 of the Constitution challenging the order dated 29/8/2023 passed in Mize case number 27/2023 arising out of money suit number 10/2021, whereby the learned court of the civil judge Sirang at Kazalgaon hereinafter referred to as the learned trial court had rejected the application under Order 6 Rule 17 of the Code of Civil Procedure 1908, for short, the code, filed by the defendant numbers 2, 3, and 4, seeking amendment of the written statement. For deciding the legality and validity of the said impugned order dated 29/8/2023, this court finds it relevant to take note of certain relevant facts leading to the filing of the instant proceedings. The respondent herein, as plaintiff, had instituted a suit being money suit number 10/2023 for recovery of an amount of rupees, for recovery of an amount of rupees, no, for realization of money on account of the contractual obligations, semicolon, for recovery of the security deposit along with interest, in the said suit, the defendant numbers 2, 3, and 4, who are the petitioners herein, filed a written statement thereupon an application was filed under Order 6 Rule 17 of the Code seeking amendment of the written statement, which was registered and numbered as Ms. case number 27/2023. To the said application, the plaintiff, who is the respondent herein, filed objection on the ground of maintainability, and other grounds. On the ground of maintainability, as well as that the amendment will bring a new and contradictory plea in the suit. And the very nature and character of the suit may be changed if allowed. Next. The learned trial court, that is the court of the civil judge Sirang at Kazalgaon, by order dated 29/8/2023, rejected the said amendment application primarily on the ground that in absence of any proposed amendment, the grounds shown by the defendant are not sufficient to allow any amendment in the written statement, as there is no new facts or changed circumstances which needs to be introduced before the court. It was also observed that the amendment may divest the plaintiff of any advantage which it had secured as a result of admission by the parties seeking amendment. It was also observed that the amendment sought by the petitioner on the ground of inverted comma original sanction orders issued by the government of India and other grants are fake and does not exist, inverted comma, is not necessary for the purpose of determining the real controversy between the parties, as the defendants have already pointed out the detection of malpractice by their officials in their written statement and admitted the work done by the plaintiff. The trial court further observed that the plaintiff should not be the victim for malpractice of their officials if the plaintiff otherwise have acted bona fidely. It was also observed that the amendment may cause injustice to the other side, as it seeks to withdraw clear admissions made by the petitioner in the earlier pleadings. Being agreed, the instant proceedings have been instituted by the defendant numbers 2, 3, and 4 as petitioners. I've heard Mr. Now, K. Musairi, R. Musairi, the learned counsel appearing on behalf of the petitioner, and Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the respondent. Yes, no state counsel. Finance.
What's the name of case that he was supposed to be?
And Mr. A. Solia appears on behalf of the finance department of the government of Assam, who is the defendant number 1. And have duly taken note of their respective submissions. Next, Order 6, Rule 17 is the provision of the code, is the provision by which any party to the suit at any stage of the proceeding may seek alteration or amendment of his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. However, for the purpose of carrying out the alteration or amendment of the pleadings, the court has to allow has to grant the permission. There's a proviso which was brought into effect. There's a proviso to the said provision which stipulates that no application for amendment shall be allowed after the trial had commenced unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of the trial. In the backdrop of the above, if this court takes note of the application which have been filed by the petitioners seeking amendment of the plaint, amendment of the written statement, it would be seen that the said application is bereft of any particulars as to what amendment has been sought for to be inserted to the written statement, to be what amendment have been sought for. As there is no mention in the said application as to what are the paragraphs in the written statement which the defendants would require to be substituted, or any paragraphs to be added, inserted. Under such circumstances, the said application on the face of it was not maintainable, inasmuch as the said application, from the said application, from the said application, no person could arrive at a conclusion as to what the defendants wants to insert or amend or alter in their written statement. Though reasons, and at this stage, it may be very pertinent to observe that though reasons have been mentioned as to why the amendment was necessary, but there is no mention as to what amendments were sought for. Under such circumstances, the said amendment application ought to have been rejected at the threshold. In fact, the learned trial court was therefore justified in rejecting the said amendment application. Next. Be that as it may, it is also very pertinent to observe that when the said amendment application did not contain what was to be amended or altered in the pleadings, there was no necessity on the part of the court, the learned trial court, to observe that if such amendment would have been allowed, it would have changed the nature and character of the suit proper, would have changed the would have divested the plaintiff of any advantage which it has secured as a result of admission by the party seeking amendment, or for that matter, would amount to withdrawal of any clear admission made by the defendants in their written statement. Under such circumstances, this court, therefore, is the opinion that the impugned judgment and order does not call for any interference under Article 2 to 7 of the Constitution on the basis of the rejection of the application under Order 6, Rule 17. Inasmuch as the said application on the face of it was not maintainable. However, taking into account that what was sought to be amended having not been mentioned in the application, the observations so made by the learned trial court of divesting of the amendment may divest the opposite party of any advantage, or for that matter that the amendment may withdraw clear admission, was not called for which these observations shall not affect the decision of the would not affect the would not were not called for and were unwarranted, for which these observations stands interfered with. With the above, the instant petition stands therefore taking into account the order dated 8/12/2023 passed by this court stands vacated, and the parties herein who are duly represented before this court are directed to appear before the learned trial court on 22nd of May 2024 for further proceedings of the suit. I think this is the best.
So obliged, my lord.
Huh?
So obliged.
Because otherwise, when the amendment was not there, nothing remains. Now, how could you say that this is right or wrong? LCR has come. LCR returned. You have taken many advantages. Mr. Advocate calling for the LCR also. What is the LCR to do out?
At a point of time, I had
We'll fix it then in the month of 3rd of June.
Scanned copy was
The registry shall, the LCR has come.
scanned copy of the LCR.
Huh?
Scanned copy of the LCR. was-
But scan copy then together. And we are fixing it on 22nd. Get his written statement filed, the finance. All will be same, numbers will be different. Huh?
and so obliged.
But if there is any subsequent events which has a material bearing, can't it be brought by way of a order 8 rule 9?
Right, rule 9 by not otherwise also. Order
Taking into account, yes, you file your written statement then. But isn't it possible, not without amending, that yes, at that point of time, these officials were doing, thereafter we made certain investigation, and now we have found out these. These are additional for which I want to file an additional pleading under order 8.
That
Is
leave
it
was
not
already craved in the WS.
Huh?
That leave is, they have craved that leave in their WS itself.
No, understood. But then also they need the permission of the court.
They may apply.
So can't it be done under order 8 rule 9? And if it is done under order 8 rule 9, would it affect order 6 rule 7? Then why you are not giving those type of advice rather than filing all these things?
I do not give the petition now. my
Then
lord.
next. Oh, now I've come to the
Because we were sitting for the moon and now we got a galaxy, my lord. Of life.
Yes, what is this? LCR not received.
No,
What
my
are you
lord.
doing with the LCR of
No.
2002? It has not
My
received.
lord, the thing is that the appeal was dismissed in the year 2012. Thereafter, a review petition was filed to a different set of advocates whose names are not reflected. We are no longer.
No, file the case. It is a review.
No. The appeal was dismissed on abatement. Then they had filed a review petition.
Ah.
That was allowed, and the appeal was restored.
Ah.
So that was done through another set of advocates,
Ah.
not through Mr. Asatha.
Then
So now in the cause list, the names of the present set of counsels have not been shown.
who is that?
A. Alam and F.U. Paul Boyan. Your Lordship would kindly see review petition number 99 of 2017.
Review against what?
It was preferred against the order dated
Review was allowed.
on 12/4/2019. Was allowed.
Then
Then substitutions were done. What the record reveals, there were certain miscases which were filed for substitution of the legal heirs of the respondent number 3.
Then
Then again notices were sent. Then
to whom?
to the respondent.
Then
And then there is an office note dated 9/9/2019.
there is some FU Borbuya
Yes.
appear.
We are not in the case anymore.
Their names have not been shown.
Their names have not been.
লিখন তার নাম দেখাইছে
Only Mr. Sakar. Only
হ্যাঁ
we are no
এই
longer.
সত্তারিত আর কারো দেখো না Mr. Jed Mukit, the learned counsel appearing on behalf of the learned counsel submits that earlier his senior, Mr. A. Sattar, was appearing in this instant appeal. However, the appeal having been abated and closed by an order dated 8/11/2012, a review application was filed by a separate set of counsel. He submitted that the names of the said counsel have not been shown in the cause list, for which they may have not appeared in the instant matter. The registry shall verify the records of the review petition and verify the records and incorporate the correct names of the counsels representing the appellant and list the matter again on 13th of May 2024 by showing the correct names of the counsels.
It's a name
the name of Mr. A. Sattar be removed from the court expected. Be struck off from the
Obliged.
AP. What is the matter about? The registry shall list the matter after making due inquiry as to whether the pendency of the instant proceeding is known to the counsel whose names appear, who have been engaged by the parties in the instant proceedings. List the matter after 4 weeks. What is the CRP?
I don't expect opportunity.
Huh? CRP is for what? Order passed by so-and-so returning the claim under Order 7, Rule 10. Why? Why is there come for order? Service is complete, then you are appealing for all.
No, respondent number 2.
Service is deemed to be complete as regards. I've already mentioned. Notice in respect of any please. Okay. This court have duly taken note of the office note dated 18/4/2024, which shows that the service upon the respondent are duly complete. Considering the above, list the matter for admission on 13th of May.
I am in respect of attendant 13 only.
Who is appearing for 14? Wherever it is, service is complete. Who is response number 2? You are appearing for which insurance company?
I am appearing for insurance company. Earlier one, it was Bharti AXA, now it is merged with ICICI. So I will be appearing for.
And in both the matters, who is the insurance company? Yes, Mr. Doctor.
My lord, both the matters are covered by the decision of this honorable court.
Okay. Very well. Order 7, Rule 10, it was returned
My lord.
on the ground of limitation or
On the ground that, my lord, there is no jurisdiction.
Oh, 166.
166-2. But the learned judge was at fault in deciding that between
That judgment was not taken Mantu Sarkar.
Mantu Sarkar. Exactly, this is the decision, my lord. So honorable court has decided
Hello.
that it.
You are,
I'm for the claimant.
and you are,
For insurance company.
which one?
Earlier one, it was Bharti AXA. Now it has merged with ICICI number.
Okay. Now, where is the place where
Place is at.
you filed the claim?
Silchar, my lord.
You have an office?
Office is only in Goa.
You don't have an office.
Branch office only is in Goa. And one I think.
So the claimant resided there.
Claimant resides there.
My-
So it's okay. Then why did he return it?
I don't know, my lord. He
And
thought
this is, in fact, this is a case where the claimant did not reside, neither anybody was there.
exactly.
This case is bad. Is on a different footing.
Yes.
Held that MNCD has had no jurisdiction to entertain the claim. Further, it held that though the office of the respondent, Bajaj Alliance, has situated as Silchar, however, as no insurance policy was available on record and the insurance company also did not appear, it could not be ascertained whether the insurance company had office at Kunal Road, Silchar in the Swan. Say that one of the parties was raised by one of the parties in the year before the learned Deficiency. That was the case of mother submitted to the PhD. And you were a resident there,
I'm the resident.
both cases.
No, in the past case, I'm the resident there. In that, the second case, my lord, the National Insurance Company office is there.
Who is paying for national insurance? They have a standing council.
Yes, National Insurance. Earlier, Mr. S. Sharma was there. Senior counsel.
Where is he? Get hold of any, we have, let us have it on, we'll have it on, we fix it on when? 13. We fixed it on 13th May. Get hold of the National Insurance Council.
The first one can be typed.
Huh? No, together. Today I have already finished my quota.
Then it's okay. Part heard, dear lord.
Not necessary part. These matters, people will laugh.
15 of life.
I have one part heard. So that part heard, I am not being able to finish it. Yes, what is this?
There was some delay of 1,944 days, and we are not involved by our lawyer. And thereafter, well, the justice service was there. He did not even accept the notice. Then the lawyer concerned, because he's been made a party by name. So notice was sent, he did not receive for a long time. Lastly, we served a notice upon him through justice service. He read the notices but refused to put his signature. We have categorically mentioned all this in our justice service affidavit. That
Why have you made him perform a respondent?
You know?
Why have you made him perform a respondent? Delay is how much?
1,944 days. Every time we went to him, but he always told that okay, there is nothing to be worried about.
What case did you file against him?
It is that.
No, this can't happen. I'll dismiss this. No. Concurrent?
It's delay matter.
Concurrent?
No. In the learned trial court, we got decree, and in the RSA that was allowed.
RSA is here. RFA.
RFA, so first title appeal, the order of trial court was reversed. So this is the second appeal filed by us. Originally we got the decree. So there are merit in this case, but due to only non-informing us in time.
No, the suit was dismissed by the trial court.
Trial court. We were the
Appeal was filed by the appellant,
by
the plaintiff.
present respondent.
By the plaintiff.
Plaintiff.
That appeal was allowed. On
No, that appeal was dismissed.
No,
Here respondent is the plaintiff in the trial court. Here.
Understood. That is what I am saying. The suit was filed by the plaintiff. You were the defendants. The suit was dismissed. against that, the plaintiff filed an appeal.
Right, an appeal, yes.
That appeal was allowed for which you are here.
Yes.
That is what?
Yes.
Yes. Filed an appeal before the civil judge so and so, and the learned court below by judgment and order they allowed the appeal on contest without cause and set aside the judgment and decree dated remand. Like to state that though the judgment was delivered on contest, but the fact is that the present two related to it. Did you file an execution case?
No.
When did you file an execution case?
No.
Huh? You are the plaintiff.
Yes, my lord.
After getting the decree, did you file an execution case or not?
Yes, my lord.
When did you file?
That part, my lord, I have no idea.
You are serious or you are consenting? Do you want to consent to the delay?
No, my lord. I have filed objection, my lord.
Then if you are filing objection, why you are not serious with your objections? Can you hear me?
Yes, my lord.
Or am I not audible to you? Did you file your execution application or not?
Yes, my lord. Filed.
When did you file your execution application?
Uh,
How are you denying to those statements made out here? Why did you file an objection? Tell me.
my lord, they uh, taken plea in the delay petition, my lord. And the counsel of the trial court did not inform the.
That I also know. But
Yes.
what is your ground? That their application should not be allowed.
My lord, the title suit was uh, disposed of with the contest of both parties.
Huh?
Both parties contest, my lord.
What?
Thereafter, dismissed, my lord. Title suit, my lord. Thereafter, my lord, title appeal filed. Title appeal allowed, my lord. Execution case is filed, my lord.
When was the execution filed? Anyway, second appeal continue. Mr. Counsel, it is very sad. You don't know anything about all this. You have filed a stay application?
We have filed and we have, when we came to know about this,
Did you file a stay application?
stay application, I have no information regarding.
Here you have not filed.
Here we have not filed because there is non-substitution is there.
Understood, but you have not filed a stay application.
Stay application is for conversation this matter.
We will hold it that you have consented. Mr. Counsel,
Yes, well.
you have no objection to the condoning of the delay. On the ground that you are not in a position to assist this court by stating your grounds of objection. Where is your objection file? When did you file the objection?
They have to file-
My lord, the,
Have you filed your objection or not?
yes, my lord.
When?
My lord, in the month of February, my lord.
The learned counsel
2018.
appearing on behalf of the respondent seems to be not aware about the material facts on the basis of which he have been engaged. Full stop. Leaves the matter after 2 months. Full stop. I hope this court hopes and expects the learned counsel, your name?
M. Hussain Malik.
M. Hussain, to be better prepared on the next date, taking into account that he have been duly engaged by his counsel, by his clients, to assist the court to the best of his, to the best extent possible in accordance with law.
Most of it.
নামটো ৰঙা কিতাপত লেখক।
Please go. Now, in this matter, we have taken the steps. The process has been answered by step of it. The same has been done for it.
Hmm?
The steps has been taken.
The record reveals that the steps, the counsel appearing on behalf of the appellant submits that the steps have been taken.
As per office note dated 11/3/24, service record has been received. My lord, registered well,
It is also seen that the LCA has not been received.
answer may be required.
List the matter again after completion of the search and receipt of the LCA.
In this test lordship, party lordship is the engaged senior counsel lordship is extra lordship. Lordship is time.
What is this IA for?
Delay. First now delay the
Service is complete.
service is complete.
What is this IA for?
Back to lordship. Lordship here lordship actually 2 round cases there lordship. In the first round lordship, they filed lordship. Their case was dismissed lordship. And thereafter they again they filed a appeal lordship that also dismissed. Then lordship, they lordship, forceful lordship to occupy the land lordship. And we have to lordship, later lordship, we have to come to the court lordship again for title lordship. And in that round lordship will be those.
Why there is a delay of 1434 days?
Let them with zero and I'm fully I'm not aware of that. So he only states that he will refer to his time. This thing that I cannot give.
Who is your senior?
Party engaged lordship.
Who?
He Mujumdar lordship.
He was very much present today.
No, lordship. They engaged lordship yesterday, just engaged yesterday lordship.
So, he's a senior counsel.
He needs some time to prepare this.
So, how does it matter? He's a senior counsel.
He has the full knowledge about the case.
If he doesn't have the knowledge about the case, and if a senior counsel requires more than 2 hours to prepare once for 3-4 days of delay, are you saying that the senior counsel is not competent?
I'm not.
Then
Delay is such a 1400 days.
how does it take? It's only 9 pages of the order application to argue.
They go to this deliberation lordship, then also we need some time to take the main.
Hello. We'll have it in the month of.
My lord, last day when the matter was.
Is there any stay?
No, on last day when it is a suit for dismissal. Suit for dismissal, concurrent findings, there is no stay. Last occasion when the matter was listed, your lordship was about to be passed order and fixing the date today for final disposal. then now come up with this plea that in the delay condonation petition also same type of ground, my lord, kindly see. Paragraph 4. Earlier counsel filed with a paragraph 4. Paragraph 4. There is no ground. What about happened in earlier second appeal?
What is the ground they are stating in this application?
Only ground stating that earlier when the second appeal was filed, there was delay of 46 days. But due to non-filing of the delay condonation petition, this second appeal has been filed.
What happened to the earlier?
Earlier nothing, no explanation, nothing. Whether it was filed or not, there is
What
no
was the
record.
filing number?
Yes, the number is there, Lordship. Paragraph 4 kindly.
What was the filing number?
253896. Page 5.
Where?
Page 5, second line, Lordship.
Huh?
Page 5 in IA petition, IA, Lordship.
Page 5.
In IA.
Who is Akbar Ali? Ali Akbar.
He was the Lordship. He now he died, Lordship. He was the Lordship. Appealant number 1 or plaintiff number 1, Lordship.
Huh?
Plaintiff number 1, he was the Lordship, main person, Lordship. He is the father of the other person, Lordship. Maybe character. So, Lordship, he, Lordship, first he filed the suit, appeal, Lordship, before this High Court. But at that time, Lordship, there is not proper Oklahoma, Lordship, and a ground of delay, Lordship. So he was advised, Lordship, to take doing all these documents. But after returning, Lordship, he became, Lordship, fairly illness, Lordship, and thereafter, subsequently, Lordship, he died. And now, thereafter, Lordship, all the communication become gap.
Ali Akbar died.
Died, Lordship.
When?
In 2015.
Huh?
In 2015. After filing the earlier case, Lordship, after a few months, Lordship, he died. Now, exactly date I cannot, Lordship. Exact date service is here, Lordship. Date I have annexed, Lordship.
Then when did he die?
He died, Lordship, on Lordship. Date service page 23, Lordship.
Page
23. And date of death, date, Lordship, 1/9/2015.
1/9/2015. Then?
Then, Lordship, all communication become gap, Lordship, with the...
With whom?
With the plant council, Lordship.
Who was the counsel?
At that time, I was also the council.
You were the counsel.
Yes,
you filed the appeal.
Yes, Lord. First appeal.
And you filed the appeal without a second appeal.
Second appeal.
Without a wakalatnama.
The Oklahoma is there, Lordship, sign, all signed was not there, Lordship.
Huh?
All the signatures were not there, Lordship.
There was only one person who filed the appeal.
No,
You only say Ali Akbar filed it.
5% is there, Lord.
Where did you mention 5 persons had filed? See?
Appellants is 5, Lordship. Here, appellants.
No, we are not concerned with appellants of 5. You say paragraph 1. One Ali Akbar had filed a regular second appeal on so and so bearing serial number so and so. And expectedly passed by the so and so, so and so, so and so. However, could not be registered as it should be, has not accompanying the court petition for condoning the delay in preparing the appeal. Though the state Ali Akbar had been advised to bring the documents in writing signed by other appellants, as well as the ground of delay in order to file the petition to condone the delay. What about the other appellants? Other appellants were alive?
They are alive.
Then why they didn't do anything?
So, Lordship, actually, they also did not have been much knowledge about the Lordship.
Then no knowledge, nothing, not necessary. We should dismiss this
So,
petition.
Lordship, that's why, Lordship, I am praying, Lordship, I have to say.
Nothing doing.
Lordship, some motivation is there.
Can't help it. You couldn't get your senior counsel. I can't help it.
Yes, but no, Lordship.
Where is the
Lordship,
filing
I'll
number?
consider, Lordship,
Filing
the date,
receipt?
Lordship, any date may be.
When you file it, where is the filing receipt? Show me.
First, yes, sir.
Huh?
First, yes, sir.
Huh? Where is the filing receipt?
Filing receipt also is there, but number is the lordship, just that the case is, as a proof lordship, the case is before the court, lordship, before this bench filing check.
You are a lawyer.
Yes.
So it is your responsibility. Will condone the delay provided you are you are the person to be blamed. Because of you, this has happened. How could an appeal be filed without the wakalatnama of all the persons? Tell me, how is it possible?
And I'll also look at
That means you filed a wakalatnama naming other persons without their signatures. Obviously, you only say out here that the other person's wakalatnama signature was not there. Now tell me why we shouldn't refer you to the Bar Council. I think better off we refer you to the Bar Council as to whether this would amount to a misconduct.
appreciate on the next date, lordship.
No.
Lordship,
First, let us go. You will be sent to the Bar Council. Thereafter, on the next date, we will consider as to what punishment has been given by the Bar Council, and then we will consider. If the Bar Council finds that you are not at fault, very well.
but I'll like to verify that.
We will take it up. We will send this matter to the Bar Council. Your case. Yes, your name.
I mean, kindly lordship,
You are the counsel who filed it on behalf of somebody without his wakalatnama. How can we have named? You say out here, those other person's names were there. How is it possible? You insert the name of somebody and file an appeal and get the appeal dismissed, that too to their prejudice. What happened?
It was a defective person. There was no number plotted.
Then?
It was a defective.
Then why are you not correcting that appeal? If that appeal is still there, why you are not correcting that appeal? It is on just a 44 days delay.
Thereafter, actually, what happened, thereafter, this case was filed under the guidance of another senior counsel. That senior has died.
Who is the other great senior counsel?
Senior counsel B. Banerjee was there. At the time, filed.
His name is not there.
In main case, his name is there. In main case,
Then?
But actually, the advisors, at the time, my senior counsel advised it. Therefore,
We'll have it after 2 years. In the meantime, let the inquiry be conducted by the Bar Council upon you. Better off. We'll hear the Bar Council, let them consider your case as to whether you are at fault or not. You admit that you were the counsel earlier.
Yes, sir.
Yes. So we refer your name to the Bar Council. And Bar Council let the Huh?
I'll after in the next any date to be given.
Tomorrow?
After 1 month, 1 week.
No. Nothing.
Okay.
Forget about your senior. First of all, are you aware that this court does not grant adjournments on senior counsels? I'm very clear. From the date I have set on the chair, I don't grant any adjournments on senior counsels. For me, a senior counsel is a daily wager. He comes out there, he will be given whatever fees, whatever may be, that is what he is. For me, he is nothing more than that. He's only to assist. He is only to assist the court upon the instructions being given by you. Nothing more than that. So a senior counsel's telling me anything about a senior counsel has no meaning before this court. You may make all these things stated anywhere else, but not before this. Huh?
My senior counsel can at least visit very well 10 minutes because I am also
You were the main problem.
My lord,
You are the main person behind all these things and you don't know.
my lord, actually what happened, if earlier case was revived, then it awaited. That is why purposefully this second appeal has been filed by incorporating the name
Earlier
of the
case was
victim.
revived.
No, if it is revived, the earlier one, then it will be abated. That is why they have purposefully filed by naming the legal year in this case and filed this appeal. Because
They
earlier
did
one
not
was,
rectify the mistake out there.
if that rectified, then there will be
Okay.
no
List the matter again on. When did you file this?
yes. This case was
The second appeal, the earlier second appeal? You have given a number. This, when did you file it? On 25/5/2015.
Yes.
List the matter again on 6th of May 2024. On which date the registry shall apprise this court as to whether any second appeal was filed on 25/5/2015 bearing serial number 253896. Yes.
Hello. So the response number 4, my lord. The lordship wanted to know that.
What is this IA for?
I is for stay. Order 41.
Yes. Response number 4.
I have given that death certificate number. The date is 21/9/2013.
Before much prior.
During the first step, the title.
First appeal is 1.
First appeal was disposed on 2019.
No, that is okay. Again,
Since 2012. During the appeal matter.
where is the first appeal judgment? 2012.
2012. And it is dismissed on 23/12/2019.
Let's see the plain.
Plain, your lordship will find page 8. Page 8. The present respondents are the substituted of the plaintiff.
The plaintiff won the case.
Yes.
And the present respondent, the suit was decreed or dismissed?
Suit was decreed. Suit was decreed.
So the suit was decreed in favor of Kamakhya Prasad Khemani.
No, suit was decreed in favor of the present respondent. They were substituted at the time. Yes.
So the suit was dismissed.
Decreed.
Allowed you.
Was it decreed in favor of Kamakhya Prasad Khemani?
Kamakhya Prasad Khemani.
Thereupon Kamakhya Prasad Khemani expired.
No. During the suit itself, the Kamakhya Prasad Khemani died, and his legal heirs were substituted. So it was decreed in favor of the present respondent. The substituted
His
legal heirs.
legal representatives were substituted in the suit.
In the suit.
And then he filed the appeal against the dead person.
No.
Against a normal person.
Normal case. And during the appeal, the response number 4, that is the substituted legal heirs of the plaintiff.
So it was a joint decree for declaration of right title and
Yes,
interest
joint decree.
and delivery of khas possession.
Yes.
If that be so, can the instant appeal be maintainable? And that too without filing an application. Whatever may be, person dead is dead. Huh? No, that number 4 is not there.
4 is not there. Legal heirs of 4 has signed it.
4 legal heirs have signed only. But anyways, the problem is this: you file an application under Order 22 Rule 4 with all this other two Jingbang applications. After filing those, I think this is a case for remand to the learned first appellate court. After setting aside, the second appeal was,
Second appeal is admitted.
the appeal was also dismissed.
I tried to find out, my lord, whether there is a substitution in the records or not. But the record has been sent from the district court. But I don't think it was that.
Okay, anyways,
Died in
Mr.
2013.
B. Kaushik, appearing on behalf of the respondent number 2, 3, and 5, submits that the respondent number 4 expired on 21/9/2013. The above would show, and in that regard, he had placed before this court a death certificate of the Kolkata Municipal Corporation, which is kept on record and marked with the letter Y. Taking into account the above, no, the above would therefore show that the respondent number 4 expired during the pendency of the first appeal. The learned counsel appearing on behalf of the appellant seeks for an accommodation. Lists the matter after how much? Has it been admitted? No.
It is admitted.
Stay?
Stay cannot be.
Oh, is dismissed. For an accommodation of 2 weeks. 2 weeks you will be able to do. For you, I am asking, you'll be able to do 2 weeks. Let us make it from weeks to months. 2 months. Yes, you have not taken steps upon respondent number 7 and 8.
7 and 8, through mistake, my lord. There are 2, 3 IA, my lord. So it was taken in some other case matter. So I may be excused and given to the 3 case that matter.
Mr. M.H. Rajbarbhaiya, appearing on behalf of the applicant submits that he may be permitted another 7 days time to take steps upon the respondent number 7 and 8. Permission granted. The applicant is directed to take steps upon the respondent number 7 and 8 by way of registered post as well as usual within 7 days from today. This is the matter of the completion of service.
And on behalf of respondent number 2, 3, 4, and 5, we prepared our affidavit and sending for vetting. It will be after 2 weeks.
WBC, what is this? Why is this WBC before?
It was allotted to it.
Huh?
It was allotted to it.
Why? I've stayed the order. I've stayed the order. Impugn order is stayed.
Yes.
Respondent number 7, promotion is allowed,
Yes.
but only 6. Huh? And what has happened now? Service upon respondent number 6 is presumed. Who is appearing for respondent number 6? Huh? What is the address of respondent number 6? Because respondent number 6 is the main person. Huh?
Yes, yes.
Ward number 12, Dhuri near. Official address of the election.
It is in the court of the district judge, no?
District Judge Dhuri.
I think the people from district judges, district and session judge Dhubri, they will be knowing where the response number 6 is.
My lord. So, I think when instead of sending it to the official his residence, it send it through my lord office, my lord. That will be better.
I think better off.
Better.
He will give you a copy. You get it. You are the GSC.
My
You have from Guwahati High Court. You get it,
My
sir.
lord.
This court have duly taken note of the office note dated 22/3/2024, wherein it has been mentioned that the service upon the respondent number 6 can be presumed. Six and 7 can be presumed. It is seen that both the respondent number 6 and 7 are beneficiaries of the impugned order dated 3/3/2022, issued by the district and session judge Dhubri. In the opinion of this court, that the district and session the office of the district and session judge Dhubri would have contact with both the respondent number 6 and 7. Taking into account that there is a specific challenge to the appointment of the respondent number 6, which have been stayed by this court. It is the opinion of this court that the service again be effected upon the said respondent number 6 and 7. This court further taking into consideration that the respondent number 7 is presently working under the establishment of the district and session judge Dhubri, and the respondent number 6 was a beneficiary of the impugned order, directs the counsel for the petitioner to serve extra copies, two extra copies to Mr. So-and-so, the learned counsel assisting Mr. T.J. Mahanta, the learned counsel appearing on behalf, senior counsel appearing on behalf of the GHC, Guwahati High Court, so that the said 2 copies be sent to the district and session judge Dhubri, and the service could be effective upon the respondent number 6 and 7. List the matter again on 14th of June 2024. Interim order passed earlier. It made shall continue until further orders.
Is your lordship. Lordship, the matter bit wherever after we filed this matter bit, they came to the terms of compromise.
Very well. Something good has happened then.
Yes, your lordship. This is the agreement and the money.
File it, both of you, by way of an application.
I'm not filing it. They notice it. It is between both the parties.
Understood. You want the compromise decree?
No, your lordship, I'm looking for the case where we sent to the local data so that the second part of the payment may be made there. Then and as agreed by both the parties.
Madam, both of you file a joint application or you file a joint application, whatever may be. This court can't take judicial notice of this type of documents in this manner. File a joint, both of you have arrived at a compromise.
Yes, your lordship.
So why don't you file a joint application before this court for recording these documents, the contents of these documents to be a part of the compromise? and on the basis of which I'll pass the decree.
Lordship, can-
You go to Mr. Ghosh, he will explain what is to be done.
No, no, I understand.
Anyway, list the matter with the counsel appearing at the bar on behalf of the party submits that there is some sort of a compromise entered into between the appellant and the respondent. In the opinion of this court, if any compromise decree is required to be filed, a joint application has to be filed by both the parties, enclosing the state compromise document. List the matter of 2 weeks.
It's all right. Keep your-
Yes, okay, service complete. Okay, service complete, records received, list the matter for hearing in its usual course. Okay, give your name.
I'm for fourth. Much.
So, I got to need. Record service complete. Record received, list the matter for hearing in its usual. Yes,
This matter relates to the bypassing of this debate.
okay, we have vacated that day to your satisfaction. Now we again give it.
File petition for extension of the earlier order.
Extension, we will grant it. Question have already been formulated. He wants a stay, na?
Yes, madam. Yes.
Which is your IA?
From our side, there is another application you want.
That I will look into first.
That is
41 rule 5.
yes.
Okay. Okay. IAC 1190/2024. Heard Mr. L. Vishwas, the learned counsel, appearing on behalf of the applicant, and Mr. S. Ali appearing on behalf of the respondent. So this is an application for stay of the judgment and decree dated 9/11/2022, passed by the learned court of the additional district judge number 3 Kamrup Metro at Guwahati, entitled appeal number 5/2020, affirming the judgment and decree dated 3/5/2019, passed in title suit number 354/2012 by the court of the civil judge number 1, Kamrup Metro at Guwahati. This court have duly taken notice of the fact that the appeal has already been admitted by formulating 2 substantial questions of law on 18/1/2023. The record further reveals that the LCR have been already received, and there is a direction for hearing the appeal in due course. Taking into account the above, it is the opinion of this court that the impugned judgment and decree dated 9/11/2022, passed in title appeal number 5/2020 by the court of the additional district judge number 3 Kamrup Metro at Guwahati, is required to be stayed till the disposal of the appeal, inasmuch as not staying the judgment and decree would render the appeal which have been admitted infructuous. Consequently, this court therefore states the impugned judgment and decree dated 9/11/2022, passed by the learned court of the additional district judge number 3 Kamrup Metro at Guwahati, entitled appeal number 5/2020, till the disposal of the appeal. Now, yes, what is your thing?
My application, your lordship, that is IA 1167.
For early hearing?
Early
Okay.
hearing, your lordship.
What is the reason? You are old people.
No, this is a partition to your lord.
Okay.
Partition to brothers and sisters. Your lord.
Okay.
4 sisters, 1 brother.
This is an application IA 1167/2024. Heard Mr. S. Ali, the learned counsel, appearing on behalf of the applicant, who are also the respondents in the connected appeal, and Mr. S. Biswas, the learned counsel, appearing on behalf of the appellant. It has been submitted that this is an application for early hearing of the connected second appeal on the ground that the appeal, that the suit proceedings arises out of a partition proceedings, and the parties, except the applicant number 5, are and the parties
Sisters and brothers.
are brothers and sisters, and would therefore require an early resolution to the family dispute. If further submitted, the prolongation of the instant dispute
Will be different.
If further submitted that the prolongation of the family dispute is only going to further derail the family relationship, and as such, the matter requires an early disposal. Mr. S. Biswas, the learned counsel, appearing on behalf of the respondent, appellant, has no objection to the said prayer. Taking into account the above, the court allows the instant application, thereby fixing 4th of June 2024 for hearing of the connected regular second appeal. And what is this IA? Oh, this IA close it, huh?
Yes.
22. This is what I this for stay.
Stay, my lord.
এখন এখন লিখিব 1/1/2023 হ্যাঁ তাত লিখিব that taking into account the order which have been passed in প্রথম আইকন number the order passed herein, the order to be passed herein is duly being addressed, and as such nothing further survives it. It was here service complete. It 25. Service complete. Record received. List the matter for hearing in the evening.
In this matter, my lord, this second appeal is filed by my lord, misrepresenting the fact, my lord. The order is passed in my lord, miscase, my lord. There is no judgment, no decree, is my lord. There.
Let me see where is the other side.
It is mentioned, my lord, judgment and decree.
25 video.
That delay condonation petition is, my lord, in the miscase in order, my lord, page number 67. The appellate court passed the order, my lord, page number 67.
Where is the order?
67, my lord, page number. Though I have not been, my lord, provided the annexures, my lord. Only the memo of appeal is provided, my lord. I have gone through the record, my lord, and found that, my lord,
that appeal was dismissed.
yes, my lord, on delay ground, my lord.
So appeal will lie. It's rightly done.
No, my lord.
It's an appeal.
Yes.
See, earlier also, I also thought in your life, this was the view which was taken by the full bench of the Calcutta High Court in 1987. Thereafter, in 2002, the Supreme Court overturned the said proposition and say that when a judgment is when an appellate court dismisses an application under Section 5, it confirms the decree passed by the trial court. And accordingly, it becomes a decree.
So it is a
And a second.
so it is a matter.
My lord,
In this matter, my lord, as per office note,
the LCR is received, my lord.
So therefore, I'm picking it for in usual court.
My lord,
Hearing.
I have some.
There's a line like it. Liberty is, however, given to the parties to file appropriate application for early loan. Service upon the respondent number 3 is yet to be complete. To list the matter after completion of service upon the respondent number 3. It will go to the list. Service is complete and LCR having been received, list the matter for hearing in the usual court. The service upon the respondent number 6A, 14, 19, and 20 being not complete, list the matter as well as the LCR having not been received, list the matter after completion of service and receipt of the LCR.
The name may be struck off because they have not contested with us.
6A, 14, 19, and 20. Let's wait. No, or okay, we do one thing. We may strike off them.
Later on.
Huh?
After the open.
The appeal has been admitted.
Yeah.
You got to stay as. Huh? Then you have an urgency. Then with this will keep on going on. So you want to strike off?
Name may be struck off.
Mr. S.K. Ghosh, the learned counsel appearing on behalf of the appellant, submits that the respondent number 6A, 14, 19, and 20 did not participate in the suit as well as also appeal proceedings. Appeal
Appeal as well as
also. That is what suit as well as the appeal. So he therefore submits that as the said respondents have not participated in the said proceedings, their names may be struck off. Under such circumstances, in view of the said prayer, the names of the respondent number 6A, 14, 19, and 20 are therefore struck off. The counsel for the appellant is directed to file a fresh memo of parties before the registry of this court by 3/5/2024. Thereby giving the names of those parties, thereby in view of the above order. It is also seen that the LCR have not been received till date. The registry shall take necessary steps for requisition of the said LCR and list the matter immediately upon receipt of the LCR. You file a proper memo of parties because otherwise for them it will continue. Okay. Yes, Mr. Mazumdar. You did not appear today in another matter, 1434 days.
He wanted to come on Saturday to reach me. Saturday.
He said that her papers have been given 2 days before. I said that as a senior counsel required 9 days to prepare a memo in condonation application.
He told me that Saturday he'll come with a plea.
He said that I have engaged him.
No. This is the secretary where there is a delay.
29.
29.
Yes, how much is the delay?
Delay otherwise is 773 days.
Hmm.
But my lord, earlier we filed.
You are appearing for the others?
Yes, my lord. Respondent number 1 and 2.
You are going to file your objection?
Yes, my lord.
The learned counsel appearing on behalf of the respondent numbers 1 and 2 submits that they would like to file objections to the instant application seeking condonation of delay. List the matter again on 10th of June 2024. In the meantime, the reply be filed.
Obligement.
I'm paying for sole respondent, my lord.
Which one? 30.
30 minutes.
What is this? Delay?
Delay.
How much?
90 days, my lord.
Huh?
90 days. I am for respondent, my lord.
We condone this.
My lord.
Unnecessary.
My lord.
It is an application for condoning the delay of 90 days in preparing the accompanying second appeal against the judgment and decree dated against the judgment and decree dated 29/11/2022 passed in title appeal number 6/2018 by the Court of the Civil Judge Dibrugarh. This court have duly perused the grounds which have been mentioned in the said application and have also heard Mr. R.K. Mishra, R.S. Mishra appearing on behalf of the respondent. In the opinion of this court, taking into account the grounds and reasons along with the enclosures made therein, this is a fit case for condoning the delay of 90 days in preparing the accompanying second appeal. Accordingly, the instant application stands allowed by condoning the delay of 90 days. I stands disposed. The registry shall register the accompanying second appeal and list the second appeal at the stage of Order 41, Rule 11, as per the convenience of the registry. Yes, what is it, Mr.
Confirmation petition is there, my lord.
How much?
My lord,
Mr. Sheikh, you come up with
there, my lord.
808 days, 1192 days. Why?
One thing your lordship will consider. That,
You have filed objection?
Yes, lordship. Kindly 2-3 of time.
That objection is not on record. Mr.
R. Islam.
Appearing on behalf of the respondent submits that an objection has been filed on behalf of the opposite parties against the delay condonation application.
Copy is not given. Copy is not given.
Not filed, lordship. I will file.
Oh, Mr. R. Islam, the learned counsel appearing on behalf of the opposite party submits that they are that the opposite parties are taking appropriate steps for filing the condonation the objection to the condonation application within 2 weeks from today. He therefore submits that some time may be granted in that regard. It's the matter again on 3rd of June 2024. We have not reached May, na? It's the matter again on 22nd of May 2024. The objections be filed by 17th of May 2024.
Yeah, please, your lordship. My senior Jitu's daughter is not keeping well. Kindly don't matter.
Who died? Plaintiff died. When did the plaintiff die?
Sometime in the year 2017. The appellant had died. Well, sometime in the year 2017.
Not now.
No, man.
How do you know?
It's in the application.
You file your objection?
No, madam. We have not filed. We have not filed any.
You are appearing for whom?
For the respondent number 3, 7, and 8.
Who died?
My lord, the appellant died.
Appellant died?
Yes, sir.
And the appellant had stayed only 7 days.
8 days.
Where is the death certificate of the appellant? 12/10/2017.
Yes, sir.
And you filed this application in 2023. Why you are saying 8 days? Oh, no, it was filed on 28th of March 2018.
Yes, sir.
Then?
My lord.
It is one application. both the applications are taken up together for for disposal by this common order. It appears from the record, the appellant herein expired, whole appellant, on 12/10/2018. Full stop. Leaving behind whom? Leaving behind the petitioners to the application. Full stop. Thereupon, the instant application. Thereupon, two applications have been filed. One is an application for condoning the delay of 8 days, and the other is an application for substitution of the legal representatives. This court have seen they have perused the application and the grounds stated therein, and is of the opinion that the same constitutes a sufficient cause in condoning the delay of 8 days. Further to that, this court also is of this court also being aware of the fact that this court also taking into account that the right to sue survived upon the legal representatives of the appellant, deceased appellant, substitutes the petitioners numbers 1 to 6 as appellant number 1A, 1B, 1C, 1D, 1E, and 1F to the accompanying appeal. Accordingly, the instant application, both the applications stands allowed. Further to that, this court directs the counsel appearing on behalf of the appellant to file an amended memo of parties before the registry of this court by 3/5/2024. And on the basis of the amended memo of parties, the registry shall make necessary correction in the cause title as well as also update the same in the CIS. Here, records have been received. Here are the orders.
My lord, the appeal was admitted on by order dated 29/7/2016. My lord, order dated 29/7/2016. Appeal was admitted. Substantial presence of normal cause.
Hello. You can list the matter. Records have been received. The registry shall inquire as to whether the LCR has been received or not, and thereupon, and if so received, list the appeal for hearing in its usual course.
Thank you.
The counsel for the appellant is not ready or not.
Okay, counsel for the counsel appearing on behalf of the counsel appearing on behalf of the list the matter up to for review petition. Yes, what is this review?
And I had a application for review of the order, my lord. It was done, no notice was served on me.
and there's the adverse remark made on against me, my lord. And
What?
the lordship kindly see the execution case, my lord. The execution proceeding.
Where is my order?
That is not your lordship order, my lord.
Whose order?
Order is by the Honorable Justice Sindhamullah Budeguru. Case 57, my
Page
57.
7. Why didn't you file it when he was here?
So, my lord,
67.
57. 57. Your lordship kindly page 57.
Yes.
That, my lord, your lordship kindly see, my lord, page 58. Advocate MS Bhattacharya appearing for Jahana Begum and 5 others. Actually, MS Bhattacharya only for the appearing for the railway only. And my lord, I have seen the sake of the order of that record, my lord, no notice, and we have not received any notice, my lord. We have not received any notice, my lord. That execution proceeding is going on in my lord Dhubri. And there is the attachment order. Against that attachment order, my lord, they came before the honorable court. And that attachment order was stayed, but they did not produce any document in the court below. That was going on in the court below. In court below, my lord, the government filed an application for vacating the attachment order, and we support it. And that is vacated in the court below, my lord, long back. But it is adjudicated here, my lord.
Yes, Mr. Mazumdar, what problem you have put?
And my lord, we have not received any notice, my lord. There is no record that we have notice on serve on, my lord. They have taken space, my lord, in the main case.
Problems are many here.
Probably, my lord, communication gap.
Communication back in my learned friend's client filed an execution before the executing court for executing the award, passing the land execution. Now, from the state side, he paid for time because requiring authorities a railway. Now, possibly after the award amount was paid, it was enhanced by the reference code. Before the reference code, railway is not a party, they are not aware. So anyway, my lord, before the executing court, when time was paid, when application was filed for attachment of a particular account of the government, attachment was issued. Thereafter, we came before this court. The court has passed an interim order. Thereafter, this interim order was produced before the court below. In spite of that, if they have the major statement, page 9 or so, kindly see. Before the court below, where my learned friend's client is appearing, the interim order passed by the court was intimated. So they are aware that civil petition is going on. In spite of that, they did not appear before the court. This honorable court was unable to dispose of the matter because of the non-appearance of the respondent. Now, ultimately, when I was appearing, I had no way out because railways have preferred an appeal within the application for condonation of delay against the order passed by the reference court. They are not pursuing. Now, requiring authorities not pursuing, keeping quiet. They are pursuing their matter. They are not appearing before the High Court. At that situation, my lordship kindly see this honorable court was also annoyed because of the conduct of this present petitioner, my lord. Then the court has made an observation. Lordship kindly see what is the observation here.
Now what is that?
Now they say
so the order has to vacate.
Yes.
That's all.
They want a review because railway, when I got the railways appeal tagged with this matter, they appeared they wanted to withdraw the appeal.
Who?
Railways. Then they said we are withdrawing the appeal because we have made the entire payment to the landowner. No, that was their statement. I'm saying what they stated. Thereafter, they withdrew their appeal. They withdrew their appeal, and this since they have said that and they have paid the entire amount in installment, initially 50%, subsequently another 50%. So there is nothing remains. Thereafter, the court disposed of the matter. Then this court made an observation that if the landowner has received the entire amount, why are not they informing this on the court as well as the executive court below that they have received the amount? Now they filed a review petition saying that we have not received the entire amount.
Yes.
Now, I do not know, they may not have received, but it is for the railway to pay. And we are only the acquiring authority. Railways have taken a
now he has a problem out here because of that observation.
No.
According
to him, he has not
there is an order to stop the execution. Your lordship kindly see, my lord, then why government of Assam file a application before the honorable court below to vacate the attachment order? That was there, they are fighting there, and in fact we support it.
that yes, if they go to pay 50%, then my lord,
The problem arose because of you.
no, my lord. They
Yes.
have not received any notice, my lord.
Why did you file a reference case without making the railway party?
Your lordship
that
is
is
aware that
different.
Himalayan
No,
tiles.
so that, my lord, in that execution proceeding, my lord, that railway says that they filed an appeal, but they did not produce any record before the court below, my lord. So now, my lord, I am not on that, my lord. Your lordship kindly see, please, why I am paying for review of this order, my lord? Because in this order, if it is deferred by the state of Assam, my lord, they did not take any step, my lord. They notice on serve on me, my lord. So without serving any notice, my lord, how can I appear before this honorable court, my lord? The railway council who appeared, my lord, she was shown as appearing before on behalf of the respondent, my lord.
Look, don't worry.
Your lordship kindly see, my lord.
We'll take it up. No, we'll do what?
Exactly. Railways should be
No.
your lordship.
No, my lord, that
Everybody is appearing?
They have withdrawn their appeal.
No, it's okay. No, he wants only that he should be heard. You have a copy of the petition now?
my lord.
You have a copy of the petition, the original petition, CRPIO? Fantastic. We'll do one thing. List this matter along with, so CRPIO is here.
CRPIO 40 of 2020, madam.
CRP 40 of 2020. No, CRP 40 of 2020 is different. I have passed some on. What is this? HR Khan, the learned, no, they have put the wrong file here.
Yes, sir.
Okay, list the instant review application on
Yes.
1st of May 2024 along with CRP IO 40/2020. It is seen that in the records, CRPA 40/2020 have been attached, tagged. The registry shall do the needful for tagging CRP IO 40/2020. This court makes it, as all the parties are duly represented in the instant proceeding, this court makes it clear that on the next date, this court would decide both the review application, and if the review application is decided in favor of the appellant, of the review petitioner, the CRP IO 40/2020 shall also be taken up for disposal. The counsels are duly asked to be prepared.
I'll file a short reply to this.
Whatever may reply.
Lordship,
You see, his only problem is not heard. We'll
Yes.
review that order and hear it and finish it off. Matter when.
Lordship would like to fix a date.
But maybe.
Okay.
Yeah.
Very well.
These type of matters needs to be finished up small.
They file early hearing petition, lordship.
Okay, none appears on behalf of the applicant on call, for which the matter stands adjourned to be listed again 2 weeks.
After
2 weeks.
3 weeks, lordship, I will be
2 weeks.
2 weeks.
2 weeks.
Obliged.
Yes.
I'm paying for adjournment for 1 week.
Oh, 35 is for early hearing, na? 36 is?
For higher competition.
Have you served the other side? No, this is the first time. Okay, issue notice. Making steps by, returnable 6 weeks, steps by way of registered as well. First time.
First time, but it is good and the main activity is dismissed as
I for what?
I for restoration.
It has been said some delay, 37?
Yes. There is delay in filing.
Then how can I do that?
My lord, the main case has already been compromised. I will not raise the main case.
Understood, but if they want to restore it, how do I restore it without the condoning?
25.
One day also I can't.
So in the second appeal, I will not say. Because of
Understood, but how do I do this? Tell me. I can't do that. It would be not proper.
name
In
of
fact, yesterday I was just thinking, today I was thinking, the first, second appeal which was fixed, came up in order 41 rule 11. The order which was being passed by the learned first appellate court is palpably wrong. Did not take into consideration the limitation period which was duly taken care of by the Supreme Court. And then also held it that it was barred by limitation.
will not this limitation for that.
And let me tell you, I can't do that unless I hear them. One day also, I have to just give them one chance also.
Yes, that,
Okay,
their name has
issue notice making it returnable by 4 weeks. You want to take the stick? It can be finished up.
may say I may have copy to the appearing court the other.
Oh, other side is there.
Yes. Because the matter has already been settled. We will not face second appeal. Good for
You
dismissal.
explain it to them, you issue notice and making it returnable by 3rd of June 2024. Good. The petitioner and the applicant, the appellant is applicant is given the liberty to serve copies of both the applications to the counsel who earlier represented the respondents in the second appeal. I hope he received. Yes, what is this? You are filing objection?
I will file lordship. 1329 days.
Bhattacharya appearing on behalf of the respondent.
Number 1.
Number 1 submits that she would be filing objection against the applications seeking condonation of delay. This is the matter after 3 weeks. This is the matter on 10th of June 2024. The objections be filed by 5th of June.
Apply. I am for
He
I am for respond number 1.
is appealing for respond number 1.
Yes.
Performer respond number 2 has expired. Why you are going for abatement, setting aside abatement? Go ahead.
There are some difficulties.
Why? Why you are making them a performer respondent then?
In the main suit, they are made different.
Then?
But in the title appeal, they have been recorded as performer respond.
So what? Then he is the main defendant.
The main defendant.
Then
There may be some difficulties in future, therefore I have filed.
you are appearing for the first time. How? You are appearing for the first time here
Yes.
in this matter. We have to issue notice that you have made the legal representative the party, opposite
Yes.
party in the instant application.
Yes, that's for respond number 2.
Issue notice on the opposite party in the 3 applications. গোটেইকেইখনতে বেলেগকে order. Notice upon the opposite parties. Ms. P. Bhattacharya, appearing on behalf of the opposite party number 1, submits that she would like to file objection to the applications for condonation of delay. Which leads the matter again on 12th of June 2024. In the meantime, the objection be filed by the opposite party number 1. The petitioner, the applicant, shall take steps upon the other opposite parties by way of registered as well as usual within 3 days.
Apply.
One side matter substitution petition side
How many days? Within time.
within time.
This is an application for substitution of the appeal number 1 who expired on
27 January 24.
27th of January 2024, leaving behind the applicants. Who has filed it? Leaving behind
Page 4. It has 2 daughters, 1 son.
names are given.
Yes, madam.
Paragraph.
Yes, paragraph 1, page 4.
Leaving behind the legal representative whose names appear at paragraph number 1 of the application. The said application is within time, and it is also seen that the legal representative of the appellant number 1, that the right to sue survives upon the legal representatives of the appellant number 1. Consequently, this court therefore substitutes the applicants herein as appellant number 1A, 1B, and 1C to the accompanying appeal against the deceased appellant number 1. The counsel for the appellant is directed to file a memo of parties before the registry of this court by 3/5/2024, and on the basis thereof, the registry shall make necessary correction in the cause title as well as also update the same in the CIS. I stands disposed. Yes, what is this?
We have filed an IA application for temporary injunction in the cooperative dispute plan.
You are paying for all the respondents?
Appellant must be.
You are the respondent.
Applicant.
Huh?
I am the
Applicant respondent, here appellants.
You want to file an objection?
Your Lordship, we have not done any construction in this part.
Do you want to file an objection or not?
Yes, sir.
You are raising a construction, is the allegation?
We have not done any construction, my lord.
Fantastic.
Fill up the
Okay. Please take on
Only to resist the floods, we have filled up the low-lying areas.
List the matter again on 28th of May 2024. The opposite party is given the liberty to file, or the opposite party in IAC 1164/2024, who is the appellant in the regular second appeal, is given the liberty to file their objections by 15th of May 2024. On 28th of May 2024, the application would be taken up for final disposal.
28. 28.
20.
20.